Republic of the Philippines. Court of Appeals. Manila. Special Former Special Former. 2nd Division. Republic of the Philippines, Petitioner. Versus. Regional Trial Court of Pasay City, Branch 111, now presided by the Honorable Ernesto A. Reyes, Anacleto Madrigal Acopiado, Anacleto Madrigal Acop, Julian M. Tallano, Register of Deeds of the Province of Rizal and Register of Deeds of the Province of Bulacan in Giginto, Bulacan. Respondents: Ernesto Solis Sr., Teodoro Tahanlangit, Bernadette Bass, Fredis Vinda Marcus, Florentino Abaya Jr., et al. Petitioners. Versus. Manila International Airport Authority, Land Transportation Office and Pasay City Government. Respondents: SIA GRSP number 70014. Members: Abdul Wahid, Chairman. Delian, Perlas Bernabe, JJ. SIA GRSP number 104604. Promulgated December 11, 2009. CA-GRSP number 70014 and 104604 Decision. Page 2. Decision. Delian, MMJ trial courts should exercise extreme caution in granting petitions for reconstitution of land titles, lest they become unwitting accomplices in the reconstitution of questionable land titles, instead of being instruments in promoting the stability of our system of land registration. One, strict compliance with the jurisdictional requirements of the law in the reconstitution of a title is vital, especially when the titles sought to be reconstituted purportedly cover vast tracts of land, as in the instant case. To absent compliance with these mandatory requirements for reconstitution, jurisdiction over the petition is not acquired. Consequently, when a court lacks jurisdiction to take cognizance of a case, it lacks authority over the whole case and all its aspects. 3. And any proceeding, or any judgment, order, writ, or process emanating from said court is null and void, and of no force and effect. Nature of the consolidated case is SIA GRSP number 70014 is a petition for under Section 9(2) of the Judicial Reorganization Act of 1985 and Rule 47 of the Rules of Court, filed by the Republic of the Philippines Republic through the Office of the Solicitor General OSG, seeking the annulment of the following alleged decisions, orders/writs/other documents which were ordered reconstituted, and, subsequently, 1. Republic of the Philippines vs. Plains, GR number 130433, April 17, 2002, 382 SCRA 215. 2. In this case, TCT number 408 alone, which was reconstituted by the Deputy Register of Deeds of Rizal Province on December 14, 2001. Purportedly covers 1,252,763,700 1,252,763,700 square meters of Metro Manila. 3. Pinza vs. Aldovino, number 50-25226, September 27, 1968, 25 SCRA 220. 4. Also known as OSG petition. 5. BP 129, as amended. SIA GRSP number 70014 and 104604 Decision. Page 3. Are sought to be implemented by respondents in LRC/civil case number 3957P, to wit: 1. Decision with compromise agreement dated February 4, 1970-6 consisting of 139 pages. 2. Clarificatory order dated March 21, 1974-7 consisting of 30 pages. 3. Decision dated November 4, 1975-8 consisting of 44 pages, and 4. Clarificatory decision dated January 19, 1976-9 consisting of 60 pages. The petition also seeks to declare as null and void the following writs, titles, and other documents purportedly issued pursuant to the aforementioned assailed decisions and/or order. 5. Alleged entry of judgment dated June 14, 1970-10 consisting of 7/6, 11 pages. 6. Alleged writ of execution, demolition, and possession dated September 10, 1974, 12 consisting of 14 pages. 7. Alleged certificate of sheriff's return dated November 17, 1974. 13. 6. CRGRSP number 70014, Rollo, Volume 1, pages 192 to 331, Annex A of OSG petition, allegedly rendered by Judge Enrique Agana. 7. ID at 332 to 361, Annex B of OSG petition, allegedly issued by Judge Enrique Agana. 8. ID at 362 to 405, Annex C of OSG petition, allegedly rendered by Judge Enrique Agana. 9. ID at 406 to 461, Annex D of OSG petition, allegedly rendered by Judge Enrique Agana, also referred to in some pleadings as clarificatory order dated January 19, 1976. 10. ID at 462 to 473, Annex E/U1 of OSG petition. 11. There are two versions -1, typewritten, and the other, computerized of what purports to be the same document, hence, the disparity in the number of pages. 12. CRGRSP number 70014, Rollo, Volume 1, pages 474 to 486, Annex F of OSG petition. 13. ID at 487 to 493, Annex G of OSG petition. CRGRSP number 70014 and 104,604 decision. Page 4. 8. Alleged letters of administration dated July 7, 1976. 14. 9. Alleged certified true photocopy of judicial form number 140, GLRO form number 68, book number 34 of TCT number T408, 15 consisting of 7 pages. 10. Alleged certified true photocopy of TCT number T498, 16 consisting of 7 pages, and 11. Alleged order of third alias writ of execution, possession, and demolition dated May 28, 1989, 17 consisting of 55 pages. Finally, the petition seeks the nullification of the orders of the Regional Trial Court, Branch 111, Pasay City dated July 7, 1997, 18 and July 11, 2001, 19, both of which ordered the reconstitution of said alleged decisions order/writs/other documents, and the order dated October 8, 2001, 20, which denied petitioner's motion for reconsideration. Meanwhile, CRGRSP number 104,604 is a petition for indirect contempt filed by petitioners Ernesto Salas, et al. Against respondents Manila International Airport Authority, Land Transportation Office and Pasay City Government for acts which allegedly violated the writ of preliminary injunction we issued in CRGRSP number 70014. On June 25, 2002. 14. CRGRSP number 70014, Rollo, Volume 1, page 494, Annex H of OSG petition. 15. ID at 495 to 501, Annex I of OSG petition. 16. ID at 502 to 505, Annex J of OSG petition. 17. ID at 506 to 560, Annex K of OSG petition, allegedly issued by Judge Sofronio CCO. 18. ID at 561 to 562, Annex L of OSG petition, issued by Judge Ernesto A. Reyes. 19. ID at 563 to 568, Annex M of OSG petition, issued by Judge Ernesto A. Reyes. 20. ID at 569 to 572, Annex N of OSG petition, issued by Judge Ernesto A. Reyes. CRGRSP number 70014 and 104,604 decision. Page 5. The facts. The factual antecedents of these two consolidated cases are ensconced in an aggregate of 12 volumes of records, 21 the bulk of which may be attributed in part to the vastness of the claims involved, but more significantly, to the tremendous number of pleadings filed, and documents introduced by various counsels, individuals, or entities professing an interest in the instant proceedings. Which pleadings and documents only serve to convolute the facts, and muddle the issues involved herein. Thus, to see our way through this daunting, and seemingly labyrinthine task, we shall narrate only such relevant and material facts and antecedent proceedings which are necessary and essential to the resolution of these cases. See GRSP number 70014. On July 1, 1997, Robert M. Del Rio, representing himself as attorney in fact of private respondents Anacleto Madrigal Acopiado A.M. Acopiado and Julian M. Tallano J.M. Tallano, filed before the Regional Trial Court of Pasay City a petition for a Constitution 22 Del Rio petition of an alleged decision dated November 4, 1975-23 which was supposedly destroyed by the fire which gutted the Pasay City Hall on January 18, 1992. The petition, docketed as civil case number 3957P24 was referred to branch 111 of the Regional Trial Court. Pasay City Respondent Court. Said decision dated November 4, 1975 was purportedly promulgated by branch 28 of the Court of 21 SEA GRSP number 70014 consists of 11 volumes, while SEA GRSP number 104604 is contained in 1 volume. 22 SEA GRSP number 70014, Rollo, Volume 1, pages 586 to 588, Annex P of OSG petition. 23 Supra, Note 9. 24 Curiously, the docket number of the Del Rio petition is exactly the same as the docket number of the original petition for a constitution whose records the former petition seeks to reconstitute. See a GRSP number 70014 and 104604 decision. Page 6. First instance of Wrestle, 25 then presided by Judge Enrique Gana Judge Agana, in civil case number 3957P26. Civil case number 3957P was allegedly for a conveyance of real property with reconstitution of TCT number 408 in accordance with Republic Act number 26 in the name of Gregorio Madrigal Acopiado. The alleged TCT number 408-27 supposedly covers 4 large parcels of land, 28 with a total area of more than 1.2 billion square meters, 29 encompassing land situated in Piraniaqui, Las Piñas, Muntinlupa, Pasay, San Juan, Taguig, Pateras, Cavite, Laguna, and Batangas. The parties in said case were Wilson Orfinada, et al., plaintiffs, versus Macario J. Rodriguez, Delfin and Aquilana Rodriguez, the heirs of Hermogenes and Miguel A. Rodriguez, Feliman Aguilar and the heirs of Fortunato Santiago and Maria Pantanella P. Santiago and heirs, Perpetua Viuda de Aquino and heirs, Pedro Gregorio / Agapito Bonson and heirs, Teodoro Lim / Felisbes and heirs, Administrator of Fort William McKinley, Fort Bonifacio, the Honorable Solicitor General, the Director of Bureau of Forestry, the Director of Bureau of Lands, the Commission of Land Registration Commission, and to all whom it may concern. Defendants, Anacleto Madrigal Acopiado herein private respondent A.M. Acopiado, Julian M. Tallano herein private respondent J.M. Tallano, intervenors. Editing supplied. The alleged decision dated November 4, 1975 rendered judgment in favor of therein intervenors and herein private respondents A.M. Acopiado and J.M. Tallano. In its lengthy dispositive portion, said decision ordered all occupants claimants government, individual, or private entity to reconvey the land to A.M. Acopiado and J.M. Tallano and to pay. 25 Now Branch 111, Regional Trial Court of Pasay City Respondent Court. 26 Supra, Note 23. 27 Certified true copy of which, as reconstituted by the Deputy Register of Deeds of Wrestle Province on December 14, 2001, was attached as an XQ of OSG petition CAC.RSP number 70014, Rollo, Volume 1, pages 592 to 594. 28, also known as Parcel First Lot 1, Parcel the Second Lot 2, Parcel the Third Lot 3, and Parcel the Fourth Lot 4. 29, the lots correspond to the following areas: Parcel I Lot 1 Plan the Second 69-140 million square meters, Parcel the Second Lot 2 Plan the Second 69-122 million square meters, Plan the Third Lot 3 Plan the Second 69-44,100,000 square meters, Parcel the Fourth Lot 4 Plan the Second 69-946,663,700 square meters. See a GRSP number 70,014 and 104,604 decision. Page 7. Said prevailing party's monthly rental, based on one's length of occupation of the lands, at the rate of PHP 50,000.00 for agricultural lands and PHP 100,000.00 for residential and commercial buildings. Significantly, said decision dated November 4, 1975 also ordered the Register of Deeds of the Province of Resel to reconstitute administratively the lost owners and duplicate copies of said TCT number 408, for and in the name of Gregorio Madrigal Acopiado, 30 in accordance with Republic Act No. 2631 RA No. 26. Accordingly, several annotations were ordered to be carried over at the back of the reconstituted title, namely: 1. Deed of absolute sale on April 7, 1937 executed by Gregorio Madrigal Acopiado in favor of A.M. Acopiado, covering an area of 29,151.768 hectares in consideration of PHP 100,000.00 32. 2. Deed of absolute sale on December 9, 1937, executed by Don Hermogenes Antonio Rodriguez and Don Miguel Antonio Rodriguez in favor of the Insular Government of the Philippines, now Republic of the Philippines, and the United States Government, covering 3,271.232 hectares and 100 hectares, in consideration of PHP 450,000.00 and PHP 15,000.00 respectively, with amounts fully paid. 30. Although the Acopiados, Acops, and Tallanos sometimes have the title Don appended to their names in some documents, which form part of the records of this case, we deemed it best to remove said titles for simplicity and uniformity. However, the titles have been retained when quoting portions of documents, where the title Don is affixed to their names. 31. An act providing a special procedure for the reconstitution of K.O.R.A.N certificate of title lost or destroyed, approved September 25, 1946. 32. Entered in the notarial registry of Juan Estrada de Figueroa on April 7, 1937, 2:00 p.m., in the municipality of Pasig, under document number 224, page number 39, book number 7, series of 1937. See a GRSP number 70,014 and 104,604 decision. Page 8. By the people of the United States of America in behalf of the Republic of the Philippines. 33. 3. Deed of absolute sale on December 2, 1953, executed by A.M. Acopiado in favor of Benigno Toda, General Manager owner of Philippine Airlines and Manila International Airport, covering 75 hectares, in consideration of PHP 1,250,000.00. Paid in the form of a donation by the Office of the President of the Philippines through the mediation of then-President Ramon F. Magsaysay. 34. 4. Deed of absolute sale on December 17, 1971, executed by A.M. Acopiado in favor of J.N. Tallano, covering an area of 15,192.9338 hectares, in consideration of PHP 8 million.00. 35. Further, The decision dated November 4, 1975 declared all occupants and those in adverse possession of the areas covered by TCT number 408 as illegal squatters who were punishable under PD 772, 36 with full force of the law. 37 Consequently, it directed law enforcement authorities 1. To immediately arrest any occupant claimant who obstructs or intends to obstruct the administration of justice, and who continuously denies, defies, or delays the implementation of the decision. 38 and 2. To clear, demolish, and remove any form of structure or building, either government or privately owned, that may be found as an obstruction to the purpose of Acop and J.M. Tallano. Moreover, it authorized the imposition of severe penalties for 33 entered in the notarial registry of Juan Estrada de Figueroa on December 9, 1937, 9:45 a.m., in the municipality of Manila, under document number 77, page number 90, book number 12, series of 1937. 34 entered in the notarial registry of attorney Jose Fernandez on December 2, 1953, in the city of Manila, under document number 21, page number 39, book number 14, series of 1953. 35 entered in the notarial registry of attorney Felipe Abregano on December 20, 1971, in the municipality of Pasig, province of Rizal, under document number 57, page 87, book number 7, series of 1971. 36 Anti-squatting law, approved August 20, 1975. 37 CRSP number 70014, Rollo, volume 1, page 400. 38 ID at 404. CRSP number 70014 and 104604 decision. Page 9. Violation of said decision, allegedly in accordance with PD 772 and the revised Penal Code 39. More significantly, the decision dated November 4, 1975 declared private respondent J.M. Tallano as the lawful owner of 15,192.9338 hectares of land embraced in parcels 1 and the 4th, 40 and private respondent A.M. Acop as the lawful owner of 14,433.1418 hectares of land embraced in parcels the 2nd and the 3rd, 41 all of TCT number 408. Accordingly, it ordered the municipal assessors of the localities embraced by the aforesaid parcels of land to declare and register the same in the names of J.M. Tallano and A.M. Acop for taxation purposes. 42. On July 4, 1997, a hearing was conducted by respondent court on the Del Rio petition. Solicitor Domingo G. Carriazo Solicitor Carriazo, who was then handling the case, appeared for the Republic. The following exchange occurred during said hearing. Solicitor Carriazo, appearing for the government, Your Honor. Attorney Rivera, for the petitioners, Your Honor. This is a petition for a constitution of the records in civil case number 3957P, which was promulgated way back in by the then Judge Enrique Gana, presiding over Branch 28, which is now Branch 111. The records of this case were burned during the fire which gutted the city hall, including this. We have court on January 19, 1992. 43 attached to the petition certified true copies of the decision which was obtained from the office of the Solicitor General, and also the affidavits of the employees of the court from the year 1975, 1973, respectively, to the 39 KG.R. SP number 70014, Rollo, Volume 1, pages 404 to 405. 40 allegedly encompassing a portion of Piranha Key, the whole of Muntinlupa, Las Piñas, Zapote, Bacor, Carmona, General Mariano Alvarez, Das Marinas, Imus, and Tanza in Cavite, and Pedro Tunazan in Laguna. 41 allegedly encompassing Pateras, Taguig, and portions of Makati, Pasay, and Piranha Key. 42 CRSP number 70014, Rollo, Volume 1, page 405. 43 should be January 18, 1992. See GRSP number 70,014 and 104,604 decision. Page 10. Present attesting to the fact that they were employees of the court when the decision was promulgated by the then Judge Enrique Agana, presiding over said court, which is now Regional Trial Court, Branch 111 of this court sake. We respectfully pray that after this hearing, the attached documents be admitted in lieu of the originals which were lost and destroyed, and that the records of this case be reconstituted. Court, from the Office of the Solicitor General. Solicitor Carriazo, we have examined the documents that were attached to the petition for a constitution, and we find them to be accurate copies of the documents that were received by the Office of the Solicitor General. It is sick being the case, we offer no objection to the reconstitution of the lost or burnt documents. Court, okay. Submitted 44 underscoring and editing supplied. On July 7, 1997, Respondent Court, through Presiding Judge Ernesto A. Reyes, Judge Reyes, issued an Order 45 declaring the copy of the alleged decision dated November 4, 1975 appended to the Del Rio petition as a reconstituted copy of the decision allegedly rendered in civil case number 3957P. The dispositive portion of the said order reads: Wherefore, in view of the above, the decision appended to the petition is hereby considered and declared as a reconstituted copy of the decision rendered in civil case number 3957P, and shall be accorded the same force, effect, and consequence as the lost destroyed original. So ordered. 44 See GRSP number 70,014, Rollo, Volume 2, pages 1294 to 1295. 45 Supra, Note 17. See GRSP number 70,014 and 104,604 decision. Page 11. In a motion for substitution dated November 25, 1997, 46 The heirs of private respondent A.M. Acopiado, heirs of Acopiado, assisted by attorney Malicio v. Amateur, attorney amateur, informed respondent court of, inter alia, the death of A.M. Acopiado on November 27, 1994, and manifested the appointment of Roberto P. Acopiado R.P. Acopiado as their representative. Thereafter, the heirs of Acopiado filed 2 motions for partial titling 47 of lands located in Almanza, Las Piñas City 48 and Ibao, Piraniaki, 49, both of which were allegedly covered by TCT number 408 in the name of A.M. Acopiado. The OSG opposed the motions for partial titling, 50 citing the opinion of the Land Registration Authority LRA 51, that the decision dated November 4, 1975 cannot be implemented by the Register of Deeds of Wrestle. The LRA mentioned 3 grounds to support its opinion. Thus first, there is no law authorizing the administrative reconstitution of a lost owner's copy of title, since the process must be judicial under the Land Registration Act 52 as amended by the Property Registration Decree semicolon 53 second, even assuming that TCT number 408 may be reconstituted administratively, the same cannot be given due course, because of the dubious origin of said title. 54 and third, the revived decision dated November 4, 1975 cannot be enforced by 46 See GRSP number 70,014, Rollo, Volume 1, pages 613 to 616, Annex T of OSG petition. 47 Ideat 595 to 602 and 603 to 612, Annexes R and S, respectively, of OSG petition. 48 Lots 12 and 15, Parcel 1, PSD 3411, 11 to 69, 49 Lots 1, 2, and 3, Parcel 1, Su 2031. 50 See GRSP number 70,014, Rollo, Volume 1, pages 617 to 619, Annex U of OSG petition. 51 Ideat 620 to 621, Annex V of OSG petition. 52 Act number 496, approved November 6, 1902. 53 PD 1529, approved June 11, 1978. 54 The LRA notes, A, Clan II as mentioned in the face of the title has not yet been applied for original registration as appearing in our survey book. B. Decree number 297 covers a parcel of land in Cavite, and not in Piranha Key as per our records. C. The alleged derivative title of TCT number 408 which is OCT number 01-4 is a well-known Spanish title. D. Clan SU 2031 mentioned at the back of the title is the same private survey number involved in the survey in the so-called Hacienda de Maricaban which supposedly covered large tracts of land, including portions of Taguig, Piranha Key and Pasay City, registered in the name of the Republic of the Philippines. See a GRSP number 70,014 and 104,604 decision. Page 12. Execution pursuant to Section 6, Rule 39, 55 of the 1997 Rules of Civil Procedure. These grounds were reiterated by the LRA in another endorsement to the OSG dated December 5, 1997 56. In response, 57 the heirs of Acop raised the following arguments. 1. The non-existence of a law requiring reconstitution of a duplicate certificate of title is a defense that has become moot and academic. 2. The dubious character of TCT number 408 was never raised at the trial, or in a motion for reconsideration. 3. The new procedural time limitation on the execution of a decision does not apply to land registration cases. 4. No less than LRC Commissioner Bilog confirmed the authenticity of the title of A.M. Acopiado's predecessor in interest. 5. After judgment has become final and executory, no question assailing it may be raised to render it ineffective. 6. The case partakes of the nature of a land registration proceeding, and is thus unaffected by the ordinary rules of procedure. Elucidating on the last argument, the heirs of Acopiado admitted that the present action was commenced as an ordinary civil case, but that the appearance and participation of the 55 Section 6 execution by motion or independent action a final and executory judgment may be executed on motion within 5 years from the date of its entry. After the lapse of such time, and before it is barred by the statute of limitations, a judgment may be enforced by action. The revived judgment may also be enforced by motion within 5 years from the date of its entry, and thereafter by action, before it is barred by the statute of limitations. 56 KG.R. SP number 70,014, Rollo, Volume 1. Pages 622 to 623, Annex W of OSG Petition. 57 ID at 644 to 648 and 649 to 655, Annexes Z and AA, respectively, of OSG Petition. See a GRSP number 70,014 and 104,604 decision. Page 13. Intervenors 58 changed the nature of the action by converting it into a land registration case 59. Thus, the heirs of Acopiado still moved for the execution 60 of the decision dated November 4, 1975 and prayed for the issuance of an order which will 1. Allow or enforcers to effect the arrest of those who will obstruct the enforcement of the writ of execution and 2. Authorize the sheriff to break and destroy any lock, gate, door, or enclosure, which shall hamper the coercive power of the writ. On February 2, 1998, Respondent Court issued an Order 61 denying the motions for partial titling, and motion for execution of the heirs of Acopiado. The order, which noted the statements of the OSG and the LRA, reads in part: until and after the Register of Deeds of Pasig, Rizal now Pasig City reconstitute administratively the owner's duplicate transfer certificate of title number 408, pursuant to paragraph 2 of the dispositive portion of the judgment, the decision of November 4, 1975 sought to be implemented, cannot be enforced in the meantime by writ of execution. Word in italics supplied. Then, on September 22, 1998, the OSG received a motion for the issuance of an alias writ of execution 62 filed by Attorney Martiniano A. Valdesimo, Attorney Valdesimo, representing private respondent J.M. Tallano and a certain Manaclita Madrigal Acop A.M. Acop. The aforesaid motion presented a number of oddities. First, while bearing the same docket number that is, civil case number 3957P as a Del Rio petition, the motion indicated a certain Anacleto Madrigal Acopos intervena, instead of Anacleto Madrigal Acopiado, the name specified in the alleged decision dated November 4, 1975. Second, it prayed for the issuance of 58 herein private respondents J.M. Tallano and A.M. Acopiado 59 SIA GRSP number 70014, Rollo, Volume 1, page 653. 60 ID at 624 to 633 and 634 to 643, annexes times and Y, respectively, of OSG petition. Annex Y, which is the supplemental motion for execution dated November 28, 1997, sought the inclusion of the Basis Conversion Development Authority, being an occupant of the area allegedly covered by alleged TCT number 408. 61 ID at 659 to 660, Annex CC of OSG petition. 62 ID at 661 to 662, Annex DD of OSG petition. SIA GRSP number 70014 and 104604 decision. Page 14. An alias writ of execution, to reconstitute not just TCT number 408, but also TCT number 498. Third but not least, it mentioned as basis for its prayer, not just the alleged decision dated November 4, 1975, but also a previously unheard of alleged clarificatory order dated January 19, 1976, 63 and an alleged decision dated January 19, 1979. 64 on September 28, 1998, the OSG filed an Opposition 65 to the above motion, invoking the same grounds discussed in its Opposition 66 to the heirs of Acopiado's motions for partial titling 67. In their reply to opposition dated October 12, 1998, 68 private respondents J.M. Tallano and A.M. Acop again made reference to the following documents. 1. An alleged clarificatory order dated January 19, 1976 69 An. 2. An alleged decision dated January 19, 1979. They also introduced, yet again, a previously unheard of sheriff's return also referred to in subsequent pleadings as sheriff's certificate of writ of execution dated May 4, 1979-70. Thereafter, private respondent J.M. Tallano, this time through attorney Paulino M. Ejacito attorney Ejacito, filed a motion to admit clarificatory order dated January 19, 1976 and sheriff's certificate of writ of execution dated May 4, 1979-71 motion to admit alleging that these two documents were inadvertently excluded from the Del Rio petition. Private respondent J.M. Tallano's motion to admit contains, inter alia, the following averments. 63 Supra, Note 9. 64 No copy of this alleged decision can be found in the records of the case. 65 SIA GRSP number 70014, Rollo, Volume 1, pages 663 to 664, Annex E of OSG petition. 66 Supra, Note 50. 67 Supra, Note 47. 68 SIA GRSP number 70014, Rollo, Volume 1, pages 665 to 668, Annex FF of OSG petition. 69 Supra, Note 9. 70 SIA GRSP number 70014, Rollo, Volume 1, pages 672 to 689. Annex B of Annex GG of OSG petition. 71 ID at 669 to 671, Annex GG of OSG petition. SIA GRSP number 70014 and 104604 decision. Page 15. 4. The petition filed by Robert Del Rio 72 inadvertently failed to include the clarificatory order dated January 19, 1976, which substantially revised, modified, and superseded the November 4, 1975 decision 73 and the sheriff's certificate of writ of execution dated May 4, 1979 certifying that the decision and the case was duly executed. Parenthetically, one of the significant and material modifications in the clarificatory order P49 is the statement that Don Juan Ejército, grandfather of President Joseph E. Estrada, and undersigned counsel is the owner of 1,040 hectares of land in San Juan and 2,600 hectares in Mandaluyong times. 5. It is extremely necessary that these documents be admitted as part of the records of the case, especially the clarificatory order, because it not only substantially modified the decision dated November 4, 1975, but also supplanted its 74 underscoring supplied. The OSG opposed Private Respondent J.M. Tallano's motion to admit. In its comment dated November 17, 1998, 75, the OSG reasoned. 1. That before the subject documents may be admitted, it is incumbent upon Private Respondent J.M. Tallano to prove their existence by competent evidence, especially since no other copy of these documents exists. 2. That compliance with the jurisdictional requirement of notice of initial hearing to all actual occupants of the subject property was unlikely, if not impossible, considering the vastness and the population density of the portions covered by the reconstituted titles. 3. That judicial notice must be taken of the notorious fact that the subject property is already covered by existing titles which must be cancelled before a constitution can take place, and 4. That even assuming the intrinsic validity of the documents sought to be admitted, their admission would be a mere academic exercise, because they can no longer be executed pursuant to Section 6, Rule 39(76) of the Rules of Court, since 10 years have already. 72 Supra, Note 22. Also known as Del Rio Petition. 73 Supra, Note 8. 74 SIA GRSP number 70014, Rollo, Volume 1, pages 669 to 670, 75 ID at 690 to 693, Annex HH of OSG Petition. Supra, Note 55. SIA GRSP number 70014 and 104,604 decision. Page 16. Elapsed from the promulgation of the alleged clarificatory order dated January 19, 1976. The OSG concluded. Whether or not the subject clarificatory judgment and writ of execution are valid and or can be executed, is material to interveners herein. Private Respondent J.M. Tallano motion, though on its face it merely seeks their admission into the records. It would be safe to assume that the admission of these documents is not solely for admission's sake. Intervener herein Private Respondent J.M. Tallano can certainly be expected to eventually seek execution of the subject court processes. Editing and underscoring supplied. Meanwhile, the heirs of Acop also vigorously objected to J.M. Tallano's motion to admit, stating that they were not aware of the existence and rendition of the supposed clarificatory decision dated January 19, 1976. 77 They argued. 1. That the request for admission failed to comply with Rule 2678 of the Rules of Court. 2. That unless a party's purpose for admission is to establish his cause of action or defense, the admission of the two documents 79 would be useless, pointless, and a mere redundance. 3. That the signatures of the certifying clerk of court on the pages of the decision dated November 4, 1975 80 and the alleged clarificatory decision dated January 19, 1976, 81 while allegedly belonging to the same person, were different. 4. That the supposed official receipts accompanying the two documents 82 were full of alterations and erasures, casting doubts on their integrity and truthfulness. And 5. That the sheriff's return was not signed and reported by the proper deputy sheriff of respondent court. Private Respondent J.M. Tallano filed a reply dated November 27, 1998, 83 defending his previous motion to admit. 77 Supra, Note 9. 78 Admission by adverse party. 79 Clarificatory decision dated January 19, 1976 and Sheriff's Certificate of Writ of Execution dated May 4, 1979. 80 Supra, Note 3. 81 Supra, Note 9. 82 Supra, Note 79. 83 SIA GRSP number 70014, Rollo, Volume 1, pages 699 to 722, Annex KK of OSG petition. SIA GRSP number 70014 and 104,604 decision. Page 17. He averred that the arguments advanced by the OSG in its comment dated November 17, 1998-84 have neither relevance nor propriety, because he is merely seeking the admission and not the execution of the clarificatory order dated January 19, 1976 and the sheriff's certificate of writ of execution dated May 4, 1979. On July 7, 1999, Respondent Court issued an Order 85 denying, inter alia, Private Respondent J.M. Tallano's motion to admit. Respondent Court ruled. The clarificatory order of January 19, 1976, assuming it validly exists and attained finality, is a judgment independently sig by itself, notwithstanding the fact that it was rendered precisely to modify and revise the decision of November 4, 1975. As such, and under the Rules Section 6 of Rule 39, Rules of Civil Procedure, as amended in 1997, it can no longer be enforced by a mere motion for more than 5 years had already elapsed from the time it supposedly attained finality. Definitely, this court had ceased to have jurisdiction to execute by mere motion the dormant judgment assuming it validly exists Viola di Decina vs. De Los Angeles, 39 SCRA 94. It cannot also be revived by a new action, because under Section 6 of Rule 39, the judgment sought to be revived must not be barred by prescription. Considering that more than 10 years had already elapsed counted from the date January 19, 1976 said judgment becomes sic final, the right to enforce the judgment had already prescribed Art 1144-8, Civil Code, and any action which may be instituted to revive or enforce the said judgment is dismissible. PNP vs. Pacific Commission House, 27 SCRA 766. Underscoring and editing supplied. Notwithstanding the aforesaid denial, Private Respondent J.M. Tallano filed an urgent motion for the issuance of a fourth alias writ of execution, possession, and demolition 86. 84 SIA GRSP number 70014, Rollo, Volume 1I, pages 690 to 693, Annex HH of OSG petition. 85 SIA GRSP number 70014, Rollo, Volume the second, pages 1175 and 1177. 86 SIA GRSP number 70014, Rollo, Volume 2, pages 956 to 974, Annex HHH of OSG petition. SIA GRSP number 70014 and 104,604 decision. Page 18. On August 22, 2000, the OSG received a letter 87 from Romeo C. Campus, who represented himself as attorney-in-fact of Private Respondent J.M. Tallano, requesting a certified photocopy of an alleged order of third alias writ of execution, possession, and demolition with dismissal, to motion for relief of the national government. Said order was supposedly 88 promulgated on May 28, 1989 and penned by Judge Sofronio C. Sao. Judge Sao, a former presiding judge of Respondent Court. The OSG denied the request on September 8, 2089 on the ground that the alleged order did not emanate from its office. A second request for other documents, dated September 15, 2090 was also denied by the OSG for the same reason. 91. Thereafter, the heirs of Acop, through Attorney Emitter and Attorney Eddie Tamandang, Attorney Tamandang filed a motion for execution dated January 18, 2001, 92 seeking the issuance of multiple writs of execution covering the different areas subject to the alleged decision dated November 4, 1975. On April 18, 2001, Romeo C. Campus, as attorney-in-fact of Private Respondents J.M. Tallano and A.M. Acop, through attorney Teresito Abella. Attorney Abella filed a petition for reconstitution with motion for the issuance of an alias writ of execution, possession and demolition. 93 Tallano Acop petition. Noticeably, the docket number and case description of what may be considered as a second petition for reconstitution indicated LRC/civil case number 3957 for quieting of title/reconveyance of TCT number 408 and TCT number T498 in accordance with Republic Act number 26. In the name of Prince Lacan Guillen Tallano, Don Gregorio Madrigal Acop, and Don Esteban Benitez Tallano. 87 SIA GRSP number 70014, Rollo, Volume 1I, pages 978 to 979, Annex JJJ of OSG petition. 88 records show that the alleged order is dated May 23, 1989. 89 SIA GRSP number 70014, Rollo, Volume 2, page 983, Annex KKK of OSG petition. 90 ID at 984, Annex LLL of OSG petition. 91 ID at 985, Annex MMM of OSG petition. ID at 986 to 993, Annex NNN of OSG petition. 92 ID at 1032 to 1048, Annex RRR of OSG petition. SIA GRSP number 70014 and 104604 decision. Page 19. The Tallano Acop petition made the following allegations. 5. On November 4, 1975, a decision was rendered by Honorable Enrique Agana in the case at bar which, however, due to the manipulation by some court clerical staff, the caption and the title were incorrectly typewritten such that the name of one of the interveners, Don Anacleto Madrigal Acop, was erroneously substituted with the name Anacleto Madrigal Acopiado. This error was systematically carried over in the 94 body of said decision. Times. 12. Neither interveners Don Anacleto Madrigal Acop and / or Julian M. Tallano, their common administrator Don Prince Julian M. Tallano, or their counsel of record, were notified of the destruction / burning of the records of the case at bar as required in sections 1 and 2 of RA number 3110. It was only very recently that the judicial administrator Don Prince Julian M. Tallano and his attorney, in fact Romeo Servants Campus, have ascertained that the records of the present case were totally destroyed by the January 18, 1992 fire. 95. 13. The case at bar was still pending and active when the January 18, 1992 fire broke out, and continues to be active and pending up to the present, since the decision with compromise agreement dated February 4, 1972, together with the clarificatory order of March 1, 1974. And the clarificatory decision of January 19, 1976 have not yet been fully executed, implemented, and satisfied to date. 96 times. 16. Aside from the imprescriptibility clause embodied in the decision with compromise agreement of February 4, 1972 against 5 years prescription period of execution, it must be pointed out that the case at bar is not a purely civil proceeding but a mixture or combination of both civil and land registration proceedings, as it prays for the reconstitution of OCT. 94 SIA GRSP number 70014, Rollo, Volume 2, page 1035. 95 ID at 1038. 96 ID. SIA GRSP number 70014 and 104604 decision. Page 20. Number T01-4, TCT number T408, TCT number T498, 97 underscoring supplied. Consonant to the above allegations, the Tallano Acop petition sought the reconstitution and execution of A previously unheard of decision with compromise agreement dated February 4, 1972, 98 supposedly rendered by Judge Agana. B. A previously unheard of clarificatory order dated March 21, 1974, 99 supposedly rendered by Judge Agana. C. The alleged clarificatory decision dated January 19, 1976, 100 supposedly rendered by Judge Agana. D. the alleged third alias writ of 97 CRGRSP number 70014, Rollo, Volume 2, page 1039. 98 Supra, Note 6. The parties to this alleged decision were Wilson P. Orfinida, plaintiffs versus Macario Rodriguez and heirs, the heirs of Don Miguel and Hermogenes Antonio Rodriguez, Dua Aurora Fabula y Cardona, Patricial Chiangson and heirs, Ponciano Padilla and heirs, Feliman Aguilar and the heirs, Fortunato Santiago and Maria Pantaleona P. Santiago and heirs, Marcus Estanislao and Mauricio de los Santos / Blas and Sebastian Fajardo / Antonio / Dulalia Agua, Don Mariano San Pedro y Esteban and Marius Ocoro Conrado heirs, the heirs of Florencia Rodriguez, Esteban Benitez Tallano, et al., Ingracio San Pedro and heirs, the administrator of Bacutan / Market Masolo estate, et al., Pedro Gregorio / Agapito Bonsanan. Heirs / Balbino Francisco, Pedro Rogers estate and heirs, Eugenio Marcelo / Juan Joseph Santiago Garcia and heirs, Ortigas and Company Partnership, the administrator of Pasay and Triple Estates and the Miracaban estate Perpetua and Perfecto Aquino, et al., Antonio Fiel, the administrator of San Pedro estate Jose Salvador / Magno Fernandez / Doña Lourdes Ochoa y Quesel. Simona estate and the heirs, Exequiel de la Cruz and heirs, Gervasio Lombo, Francisco Soriano, Quintin Mejia / Catalina Estanislao and the heirs / Joanna Cruz and heirs, Gabino Javier and heirs, the Modesto, Eulalio, Thomas, Apollonio, Pedro, Francisco and Antonio Cruz, Rafael Serrao, Jose Oliver and the heirs, the Manada de Campo Buhain, et al., Manuel Quiag, Estanislao, Eduardo and Bernabe Cardozo and the heirs, Antonio Aquiel, Dr. Nicanor Jacinto, et al., Fernando Jacinto Steel Mills Incorporated, Felix and Claudio Osorio and heirs, Regino de la Cruz / Gil Santiago, Bonifacio Regalado and heirs, Marciano Tuazan and Tuazan Company, Julian and Juan Francisco, Serrao Motors / Francisco Motors Corp., Philippine Share Company, Hilla Development Corporation, Teodoro Lim, Felix Bees and heirs, Valentino Gajudo / Candido Cleophas. Fort William McKinley and the Manila Railroad Company, University of the Philippines, through Honorable Solicitor General, the Commissioner of Land Registration Commission, the Honorable Director of Bureau of Lands, the Republic of the Philippines, and to all whom it may concern. Defendants, Benito A. Tallano, Intervenor. 99 Supra, Note 7. Said clarificatory order allegedly ordered the Register of Deeds of Wrestle and Bulacan to issue owners and duplicate reconstituted copies of TCT number T408 and TCT number T498 in favor of J.M. Tallano and A.M. Acop. 100 Supra, Note 9. Previously referred to, and introduced in J.M. Tallano's and A.M. Acop's motion for the issuance of an alias writ of execution, and in the reply to opposition, dated October 12, 1998. CRGRSP number 70014 and 104604 decision. Page 21. Execution, possession, and demolition dated May 23, 1989, 101 supposedly rendered by Judge Sao, and all other pertinent documents connected to LRC/civil case number 3957P. It also prayed for an order directing the LRAN/ or the Register of Deeds of Wrestle and Bulacan to reconstitute TCT numbers T408 and TCT number T498 respectively, in favor of Gregorio Madrigal Acop or Esteban Benitez Tallano, both of whom are allegedly predecessors in interest of private respondent J.M. Tallano. An examination of the documents sought to be reconstituted by the Tallano Acop petition reveals several interesting facts. Among others, the alleged decision with compromise agreement dated February 4, 1972 embodied an imprescriptibility clause, which allegedly exempted said decision from the 5-year period of execution for the issuance of lost original and owner's duplicate copies of OCT number 01-4, TCT number T408, and TCT number T498. 102 Interestingly, it also contained an alleged waiver of rights by the Republic over the lands, covered by said titles, with the exception of lands given to farmers beneficiaries of the land reform program of the government and lands occupied by government structures. 103 said waiver was allegedly made in favor of Julian Macleod Tallano, private respondent J.M. Tallano's predecessor in interest, by no less than President Diosdado M. Capital 104 and allegedly adopted by then President Ferdinand E. Marcos. Meanwhile, the alleged clarificatory order dated March 21, 1974 included a declaration to the effect that starting January 1, 1999, the Philippine government must pay PHP 2 billion in damages to the heirs of A.M. Acop and Julian Macleod Tallano. Thereafter, in a pleading dated May 22, 2001, Attorney Isabella, on behalf of J.M. Tallano and A.M. Acop, moved for the taking of the deposition of retired Judge K.O.R.A.N, 105 who allegedly issued the 101 Supra, Note 17, previously referred to, and introduced in Romeo C. Campus's letter to the OSG, dated August 21, 2000. 102 CRGRSP number 70014, Rollo, Volume 1. Page 322, 103 ID at 309. 104 allegedly with the assistance of then Secretary of Justice Salvador Mario. 105 CRGRSP number 70014, Rollo, Volume 2, pages 1049 to 1053, Annex SSS of OSG petition. CRGRSP number 70014 and 104,604 decision. Page 22. Purported order of third alias writ of execution, possession, and demolition dated May 23, 1989 106. The motion was granted 107. On July 11, 2001, 108 respondent court issued an order allowing the reconstitution of the following documents, to wit. Wherefore, premises considered, the following documents duly appended to the petition are hereby reconstituted as integral part of the records of this case, and shall carry the same force, validity, and effect as that of the destroyed original copy. In particular, these documents are 1. Decision with compromise agreement dated February 4, 1972, consisting of 139 pages Exhibit F and its submarkings. 2. Clarificatory order dated March 21, 1974 consisting of 30 pages Exhibit H and its submarkings. 3. Clarificatory decision dated January 19, 1976 consisting of 60 pages Exhibit I, 58 pages. 4. Third alias writ of execution, possession, and demolition dated May 23, 1989 consisting of 55 pages Exhibit A. 5. Writ of execution, demolition, and possession dated September 10, 1974 consisting of 14 pages Exhibit J and its submarkings. 6. Certification of Sheriff S return dated November 17, 1974 consisting of 7 pages Exhibit K and its submarkings. 7. Certified true photocopy of TCT number T408 marked as Exhibit L, consisting of 7 pages. 8. Certified true photocopy of TCT number T498, and marked as Exhibit M consisting of 7 pages. 106 Supra, Note 17. 107 CRGRSP number 70014, Rollo, Volume 2. Pages 1054 to 1055, Annex TTT of OSG petition. 108 Supra, Note 19. CRGRSP number 70014 and 104,604 decision. Page 23. 9. Letters of administration dated June 14, 1972 marked as Exhibit E. 10. Entry of judgment dated June 14, 1972 marked as Exhibit G and its submarkings consisting of 7 pages. Said order further commanded, thus. Accordingly, the concerned government agencies, particularly the Land Registration Administration and the Registry of Deeds mentioned in the third alias writ of execution, are hereby directed to comply with the decretal pronouncements of the executory judgments and orders of the court previously issued and which were specifically set forth and embodied in the third alias writ of execution, possession, and demolition dated May 23, 1989, 109 underscoring supplied. The OSG moved for reconsideration 110 of the above order, but this was denied in an order dated October 8, 2001, 111 thus. In view of the foregoing, the instant motion for reconsideration of the July 11, 2001 Order 112 is hereby denied. So ordered. On April 9, 2002, the Republic, through the OSG, filed the instant petition for annulment of judgment 113 with application for a temporary restraining order and a writ of preliminary injunction against respondent court, A.M. Acopiado, A.M. Acop, J.M. Tallano, and the Register of Deeds of the Province of Resel and the Province of Bulacan in Giginto. Bulacan. This was docketed as SIA GRSP number 70014. 109 SIA GRSP number 70014, Rollo, Volume 1, page 538. 110 SIA GRSP number 70014, Rollo, Volume 2, pages 1085 to 1090, Annex VVV of OSG petition. 111 Supra, Note 20. 112 Supra, Note 19. 113 SIA GRSP number 70014, Rollo, Volume 1, pages 1 to 179, also known as OSG petition. SIA GRSP number 70014 and 104,604 decision. Page 24. Antecedent proceedings in this court. On April 16, 2002, 114 we gave due course to the Republic's petition for annulment of judgment, after finding it to be prima facie meritorious. In a resolution dated June 25, 2002, 115 we then issued a writ of preliminary injunction 116 with the following rationale. Considering that the petition for annulment of judgment is based on the alleged nullity of the proceedings, decisions, and orders in civil case number 3957P on the ground of lack of jurisdiction and non-compliance with the jurisdictional requirements for the reconstitution of OCT number T01-4 and TCT numbers 408 and 498, and of the court records, the issuance of a writ of preliminary injunction is necessary to preserve or maintain the status quo of things and to prevent actual or threatened acts until the merits of the case can be fully heard. The decretal portion of the writ of preliminary injunction states, now therefore, you, the respondents, are hereby enjoined from enforcing the orders dated July 7, 1997, July 11, 2001, and October 8, 2001, in civil case number 3957P, and from conducting further proceedings in said case until further orders from this court. On February 20, 2003, we issued a resolution 117 stating the necessity of examining the records of civil case number 3957P, and of conducting hearings for said purpose to determine whether or not respondent court acquired jurisdiction over said case. Citing Barcelona vs. Court of Appeals, 118 we held that the nullity of a judgment grounded on lack of jurisdiction may be shown not only by what patently appears on the face of such decision, but also by such documentary and testimonial evidence. 114 SIA GRSP number 70014, Rollo, Volume 2I, pages 1654 to 1655, 115 ID at 1668 to 1669, 116 ID at 1670 to 1671, 117 SIA GRSP number 70014, Rollo, Volume V, pages 2575 to 2581, 118 GR number 102900, October 2nd, 1997, 280 SCRA 20. SIA GRSP number 70014 and 104,604 decision. Page 25. Found in the records of the case, and upon which such judgment is based 119. On March 3, 2004, a preliminary conference was held. The Republic was represented by Solicitor Thomas M. Lerigan, Solicitor Lerigan. Attorney Jacoba and Attorney Pacifico Yadeo. Attorney Yadeo assisted J.M. Tallano, while Attorney Emeta assisted Roberto Piacopiado, the sole representative of the heirs of Acopiado. Meanwhile, despite objections from Attorney Jacoba, Attorney Benigno Mpuno Attorney Puno entered his appearance for the Tallano Acop estate, justifying his participation thereat by arguing that civil case number 3957P was an in rem action, being a land registration case. During the course of the proceedings, the identities of Julian Morden Tallano, Anacleto Madrigal Acopiado and Anacleto Madrigal Acop were put in question. Private respondent J.M. Tallano made two claims. First, that he was the Prince Julian Morden Tallano, one of the heirs of the registered donors of OCT number T01-4, TCT number T408, and TCT number T498, and second, that it was a certain Anacleto Acop, and not Anacleto Madrigal Acopiado who had an interest over the properties covered by the aforementioned titles. On the other hand, Attorney Puno alleged that private respondent J.M. Tallano, who claims to be Prince Julian Morden Tallano, was an impostor. In a resolution dated March 10, 2004, 120, this court made the following observations. Thus, if Julian M. Tallano is not the Prince Julian Morden Tallano that he claims he is, and, therefore, an impostor, then he had no right to intervene in LRC/civil case number 3957P. There is likewise a need to determine whether Anacleto Madrigal Acopiado or Anacleto Madrigal Acop had the personality to intervene in said case. It is interesting to note that in the clarificatory order dated March 21, 1974, the court directed the Register of Deeds of Wrestle and Bulacan to issue both 119 CA GRSP number 70014, Rollo, Volume V, page 2580. 120 CA GRSP number 70014, Rollo, Volume 7th, pages 4125 to 4129. SEA GRSP number 70014 and 104604 decision. Page 26. Owners and duplicate reconstituted copies of TCT number T408 and TCT number T498 in favor of intervenors Julian M. Tallano and Anacleto Madrigal Acop here in private respondents J. M. Tallano and A. M. Acop. However, in the decision dated November 4, 1975, the court ordered the Register of Deeds of Wrestle to reconstitute the lost owners and duplicate copies of TCT number 408 administratively in the name of Gregorio Madrigal Acopiado, within a notation of a deed of sale executed by the latter in favor of his son, Anacleto Madrigal Acopiado here in private. Respondent A. M. Acopiado. Anacleto Madrigal Acopiado was also an intervener in the petition for a constitution of the decision dated November 4, 1975, in view of the burning of the records of LRC/civil case number 3957P when the Pasay City Hall was gutted by fire on January 18, 1992, which petition was granted in an order dated July 7, 1997. On the other hand, Anacleto Madrigal Acop and Julian M. Tallano were the interveners in the reconstitution of the other portions of the records of said case, which was granted in an order dated July 11, 2001 121 underscoring and editing supplied. Owing to the foregoing peculiarities and inconsistencies, this court was constrained to direct the National Bureau of Investigation (NBI) to conduct a fact-finding investigation to determine the true identities of Julian M. Tallano, Anacleto Madrigal Acopiado, and Anacleto Madrigal Acop. By agreement of the parties, the proceedings on the petition for annulment of judgment were suspended pending the termination of the NBI fact-finding investigation 122. In its disposition form dated May 24, 2005, 123 the NBI made the following recommendation. Based on its findings based on the above findings, subject Julian Morden Tallano herein private respondent J. M. Tallano, the intervener in the case of Republic of the Philippines vs. Regional Trial Court, Pasay City, Branch 111. Et al., and Prince Julian Morden Tallano, the alleged real party and interest in the above case, are one and the same person. 121 CRSP number 70014, Rollo, volume 7th, pages 4127 to 4128, 122 ID. At 4129. 123 CRSP number 70014, Rollo, volume 1X, pages 5053 to 5055. CRSP number 70014 and 104,604 decision. Page 27. As to the identity of Anacleto Madrigal Acopiado herein private respondent AM Acopiado, the only available evidence to establish his alleged existence is the altered death certificate issued by the local civil registrar of Taguig, Metro Manila on the 28th of November 1994. 124 editing supplied. On March 2, 2006, the pretrial conference was held. The following appearances were made: Solicitor Lacan for Petitioner Republic, Attorney Jacob as lead counsel for private respondent J.M. Tallano, with Attorney Manuel Natividad Jr., Attorney Virgilio C. Papa, and Attorney Vicente Taguig Jr., as collaborating counsels, and Attorney Emeta and Attorney Tamandan for the heirs of Acopiado. Attorney Puno manifested that he was appearing for the Tallano Acop estate, which is represented by Romeo C. Campos as attorney in fact. However, Attorney Puno failed to produce proof of his authority to represent Romeo C. Campos, as well as proof of the latter's appointment as attorney in fact of the alleged estate. Nevertheless, upon motion of Solicitor Lacan, Attorney Puno was allowed to appear on his own behalf as an interested party inasmuch as the case before respondent court may be construed as an action in rem when it previously directed the reconstitution of a Title 125. During the pretrial conference, Solicitor Lacan proposed for stipulation that the requirements of Act No. 3110, 126-4. 124 in the final report dated December 12, 2004, signed by Saf Laurencio C. Canlas, and noted by Heir Olivo A. Ramos. The former made the following declaration: considering the above-mentioned findings, it is the undersigned's honest opinion that there is no such person in the name of Anacleto Madrigal Acopiado, but only Anacleto Madrigal. Acop CRSP number 70014, Rollo, volume 1X. Page 5097. However, any statement recommendation to this effect was not included/carried over in the disposition form dated May 24, 2005, signed by Maria Cristina Ren Sanchez, and noted by Roberto S. D. Alban CRSP number 70014, Rollo, volume 9th. Pages 5053 to 5055, 125 CRSP number 70014, Rollo, volume 9th. Pages 5421 to 5422, see also TSN, March 2nd, 2006, page 27. 126 An Act to provide an adequate procedure for the reconstitution of the records pending judicial proceedings and books, documents, and files of the Office of the Register of Deeds, destroyed by fire or other public calamities, and for other purposes, approved March 19, 1923. CRSP number 70014 and 104,604 decision. Page 28. Reconstitution of Court Records and RA number 26, 127 for reconstitution of land titles were not complied with in LRC/civil case number 3957P, such that respondent court could not have acquired jurisdiction over said case. Only Attorney Puno admitted the stipulation 128. On the other hand, Attorney Jacob proposed for stipulation that the OSG participated and did not raise the question of jurisdiction in the proceedings before respondent court. Solicitor Lacan admitted that the OSG participated and received related pleadings, but qualified that this was only from the filing of the Del Rio petition in July 1, 1997. Solicitor Lacan also admitted that Solicitor Carriazo, who appeared in some stages of LRC/civil case number 3957P, did not raise the issue of jurisdiction of Respondent Court 129. Upon motion of Solicitor Lacan, we issued a resolution dated March 9, 2006, 130, which ordered the issuance of a subpoena duces tecum to the branch clerk of Court of Respondent Court to bring the entire records of LRC/civil case number 3957P for examination by the parties to determine compliance or non-compliance with the jurisdictional requirements of Act No. 3110 and RA No. 26. On April 7, 2006, Ricardo R. Adolfo, branch clerk of Court of Respondent Court, brought 21 volumes of records of LRC/civil case number 3957P, which, he certified, constitute the entire records of the case 131. During the examination of records, Attorney Jacoba manifested, duly seconded by Attorney Emater, that they need not examine the records one by one for compliance with Act No. 3110 and RA No. 26 because what were reconstituted were not records of a pending case but rather a finished case 132. 127 Supra, Note 31. 128 SIA GRSP number 70014, Rollo, Volume 1X, page 5422, see also TSN, March 2nd, 2006, page 45. 129 IDEAD 5422 to 5423, see also TSN, March 2nd, 2006, pages 50-54. 130 IDEAD 5427 to 5430. 131 IDEAD 5741 to 5742. 132 IDEAD 5743 to 5744. SIA GRSP number 70014 and 104604 decision. Page 29. On the other hand, Solicitor Laragan made a repeated manifestation that there was no compliance with Act No. 3110 and RA No. 26. Later, Attorney Jacoba, seconded by Attorney Emater and Attorney Puno, made a repeated counter-manifestation that the OSG had actively participated in the proceedings in LRC/civil case number 3957P and as such, was stopped from questioning the validity and legality of the proceedings in respondent court under the presumption of regularity. 133. Thereafter, the parties were directed to file their respective memoranda 134. On November 15, 2006, a memorandum 135 for private respondent J.M. Tallano was filed by Attorney Jacoba. On November 28, 2006, a memorandum 136 for proponents Romeo C. Campus, et al. Was filed by Attorney Puno, which memorandum stated that it was adopting the memorandum filed by said counsel and SC admin. Case number 6512-137. On December 22, 2006, a memorandum 138 for the heirs of Acop was filed by Attorney Dean Jaime F. Bautista, Attorney Bautista. On January 11, 2007, a memorandum 139 was filed by the OSG. On February 7, 2007, a reply memorandum 140 was filed for the heirs of Acop by Attorney Bautista. On October 10, 2007, a memorandum 141 for the heirs of Acop was filed by Attorney Emater. On December 7, 2007, a 133 SIA GRSP number 70014, Rollo, Volume 1X, pages 5729 to 5789, TSN, April 7, 2006. Sex 3 meters and 3 FF of Rule 131. Rules of court provide the disputable presumptions that official duty has been regularly performed, and that the law has been obeyed, respectively. 134 SIA GRSP number 70014, Rollo, Volume Times, page 6382. 135 ID at 6414 to 6445. 136 ID at 6741 to 6742. 137 No copy of the alleged memorandum in SC admin. Case number 6512 is found in the records of SIA GRSP number 70014. 138 SIA GRSP number 70014, Rollo, Volume Times, pages 6752 to 6819. 139 ID at 70 to 69 to 7390. 140 ID at 7401 to 7410. 141 SEER GRSP number 70014, Rollo, volume 11th, pages 7750 to 7789. SEER GRSP number 70014 and 104,604 decision. Page 30. Memorandum 142 for J.M. Tallano was filed by Attorney Homer Bono Adazar Attorney Adazar. On February 19, 2008, a rebuttal memorandum 143 for the heirs of Acop was filed by Attorney Bautista. On November 18, 2008, we issued a resolution 144 accepting the consolidation of SEER GRSP number 104,604 with CAG.RSP number 70,014. SEER GRSP number 104,604. Meanwhile, on September 6, 1999, petitioners Ernesto Solis Sr., Teodoro Tahanlangit, Bernadette Bass, Fredis Vindemarcus, Florentino Abella Jr., et al. Petitioner Salas, et al. Filed before the Regional Trial Court, Branch 112, Pasay City a complaint for interpleader against the Pasay City government, the Pasay City engineer, the Manila International Airport Authority MIAA, the heirs of the intestate estate of the late Julian Tallano, and the heirs of the intestate estate of Don Anacleto Madrigal Acopiado. The interpleader case, docketed as civil case number 99200763, sought to litigate therein defendants' respective claims of ownership over an alleged portion of the real property subject of litigation in civil case number 3957P. As previously mentioned, the Republic filed a petition for annulment of judgment with application for a temporary restraining order and a writ of preliminary injunction on April 9, 2002, docketed as SEER GRSP number 70014, before this court. Upon learning of the filing of the above petition for annulment of judgment, respondent MIAA, through the OSG, moved to suspend the proceedings 145 and civil case number 99200763. To justify its motion, respondent MIAA avert that the resolution of civil case number 99200763 depends largely on the final 142 SEER GRSP number 70014, Rollo, volume 11th, pages 7820 to 7833, 143 ID at 7895 to 7913. 144 ID at 8333 to 8334. 145 SEER GRSP number 104,604, Rollo, pages 179 to 187, Annexes C and D of Solis petition. SEER GRSP number 70014 and 104,604 decision. Page 31. Ruling of the Court of Appeals in the Supreme Court on the existence, validity, and enforceability of the alleged November 4, 1975 decision 146 in civil case number 3957 P147. The motion was granted in an order dated May 23, 2002, 148, the dispositive portion of which reads: as prayed for by defendant Manila International Airport Authority, there being a case filed by the Republic of the Philippines, filed with the Court of Appeals, under SEER GRSP number 70014, this court is constrained to suspend the proceedings in this case. So ordered. Editing supplied. On June 25, 2002, this court issued a resolution 149 granting the application for a writ of preliminary injunction in CAG.RSP number 70014, thus. Wherefore, let a writ of preliminary injunction issue enjoining respondents from enforcing the orders dated July 7, 1997, July 11, 2001, and October 8, 2001 in civil case number 3957P, and from conducting further proceedings in said case. So ordered. Much later, on July 25, 2007 and August 9, 2007, while CRSP number 70014 was still pending before this court, respondent MIAA, claiming to be the owner of part of the real property under litigation in civil case number 3957P, issued notices to vacate 150 to some persons residing along Ninoy Aquino Avenue, Atade Road, and Domestic Road, all in Pasay City. Respondent MIAA also entered into a memorandum of agreement with Respondent Land Transportation Office LTO, allowing the latter to claim the lawful use of the LTO compound, which is allegedly part of the real property subject of litigation in 146 Supra, Note 8. 147 CRSP number 104604, Rollo, pages 180, 184 to 185. 148 ID at 191, Annex F of Solace Petition. 149 ID at 192 to 194, Annex G of Solace Petition. 150 ID at 195 to 199, Annexes H, I, J, K, and L of Solace Petition. CRSP number 70014 and 104604 decision. Page 32. LRC/civil case number 3957P. Prompted by such agreement, Respondent LTO sent on May 23, 2008 and June 13, 2008, two formal demands to vacate 151 to Police Superintendent Pedro Soliva, station head of the PNP Traffic Management Group. Shortly after sending the second demand to vacate, Respondent LTO demolished and subsequently built structures, including the LTO District Building Office, within the compound. According to petitioner Sales, et al., no requisite building permit was issued by the Pasay City engineer building official before the LTO structures were built. Believing that the foregoing acts interfered with the property subject of LRC/civil case number 3957P, and thus deliberately contravened the writ of preliminary injunction we have issued on June 25, 2002 in CRSP number 700114. Petitioners filed the instant petition for indirect contempt 152 before this court on July 31, 2008. The petition for indirect contempt was later docketed as CRSP number 104604. On November 18, 2008, CRSP number 104604 was ordered consolidated with CRSP number 70014, the Republic's petition for annulment of judgment. Antecedent proceedings in this court. On December 9, 2008, petitioner Sales, et al. Moved to implead the Pasay City government as additional respondent 153 in CRSP number 104604, on the ground that said local government had supervision over the Pasay City legal office and the office of the city engineer building official, both of which facilitated the issuance of a building permit to respondent LTO. For petitioner Sales, et al., the act of approving said building permit induced the LTO to carry out acts of ownership, possession and the property subject of the injunctive writ, and 151 CRSP number 104604, Rollo, pages 200 to 201, Annexes M and N of Solace Petition. 152 ID at 2 to 12. 153 ID at 216 to 224. CRSP number 70014 and 104604 decision. Page 33. This constituted disobedience to the writ of preliminary injunction we have issued in CRSP number 70014. On April 16, 2009, 154 we granted the motion to implead the Pasay City government. Subsequently, respondents Myra, LTO, and Pasay City government were directed to file their respective comments. We received the comment of the Pasay City 155 on June 15, 2009, and the comment jointly filed government by respondents MIAA and LTO 156 through the OSG on July 6, 2009. In compliance with the requirements of Rule 71 of the Rules of Court on Indirect Contempt, a hearing on CRGRSP number 104604 was held on September 17, 2009. In said hearing, appearances were made by the following counsels: Attorney Reinaldo L. Bagatsing, Attorney Bagatsing for petitioners Ernesto Salas, et al., City Legal Officers Attorney Phidias Emmanuel R. Ramos, Attorney Mary Grace S. Bonsall, and Attorney Filipina T. Ribea Geronimo, Attorney Geronimo for Respondent Pasay City Government, and Assistant Solicitor General Thomas M. Laragan ASG Laragan of the OSG for Respondents MIAAN. LTO 157. The following also appeared to represent their respective interests in CRGRSP number 70014: Janel B. Frioniza, as Executive Administrator of the Acopiado Estate, Attorney Puno, as Counsel for the heirs of Acopiado, Attorney Cesar Anthony S. Salas, as Counsel for the Estate of Don Anacleto Madrigal Acopiado, and Attorney Adaza, as Counsel for J.M. Tallano 158. During the hearing, the parties in CRGRSP number 104604 were given the opportunity to argue their respective positions. Attorney Bagatsing manifested that he had nothing more to add to the arguments interposed in their petition. Similarly, Attorney Geronimo and ASG Laragan merely reiterated the stands laid out in their respective comments. In view of the foregoing, 154 CRGRSP number 104604, Rollo, pages 237 to 239. 155 Ideate 266 to 292. 156 Ideate 302 to 314. 157 Ideate 328. 158 ID. CRGRSP number 70014 and 104604 decision. Page 34. Manifestations. The parties agreed that the consolidated cases be submitted for decision. The issues thus, the crucial questions in this controversy, are CRGRSP number 70014, 1. Whether or not respondent court acquired jurisdiction over the Del Rio petition and or the Tallano Acop petition. 2. Whether or not the decisions, orders writs and other documents issued in connection with the original LRC civil case number 3957P are valid and enforceable. 3. Whether or not the Republic is estopped and or barred by laches from filing the instant petition. And 4. Whether or not a petition for annulment of judgment under Rule 47 of the Rules of Court is the proper remedy. CRGRSP number 104604. 5. Whether or not indirect contempt was committed by respondents Myra, LTO, and or Pasay City Government. The arguments the following are the respective relevant arguments of the parties. CRGRSP number 70014 and 104604 decision. Page 35. CRGRSP number 70014. Petitioner Republic's arguments. Preliminarily, the OSG argues that its petition for annulment of judgment is the proper remedy under the circumstances. It claims that it was filed within the 4-year period provided under Rule 47 of the Rules of Court, counted from the denial of its motion for reconsideration of the order dated October 8, 2001. As a first line of offense, the OSG posits that the assailed alleged decisions, orders writs and other documents in civil case number 3957P are void because respondent court had no jurisdiction to order the reconstitution of the alleged OCT number T01-4, TCT numbers 408, and TCT number 498, because said case was an ordinary civil action for quieting of title or recovery of ownership and possession, and not a land registration proceeding where a reconstitution of title can be validly ordered. Besides, to order such reconstitution would constitute a collateral attack on virtually all of the Torrens titles existing all over the country. Even assuming that respondent court had jurisdiction, to order the reconstitution of Atoran's title in civil case number 3957P. The OSG reasons that the assailed decisions order/writ/ and other documents are still void because respondent court did not acquire jurisdiction over the petition due to non-compliance with the mandatory and jurisdictional requirements of notice and publication in accordance with Act No. 3110 and RA No. 26. Further, the OSG contends that the assailed decisions order/writ/ and other documents in civil case number 3957P are void because they were obtained through extrinsic fraud and are intrinsically void and spurious on their faces. Finally, the OSG asserts that even assuming arguendo that there was valid reconstitution of the alleged decisions order or writ/other documents, the same can no longer be enforced on account of prescription. See a GRSP number 70,014 and 104,604 decision. Page 36. Private Respondent J.M. Tallano's arguments. Private Respondent J.M. Tallano attacks the resort to Rule 47 of the Rules of Court, based on the absence of either of only two grounds which can support the same extrinsic fraud and lack of jurisdiction. First, Private Respondent J.M. Tallano argues that there is no extrinsic fraud. For one, Solicitor Carriazo's manifestation to the effect that the documents attached to the Del Rio petition are accurate copies of the documents that were received by the Office of the Solicitor General, 159 in the hearing of July 7, 1997, belies the OSG's stand that the Del Rio petition was the first document they received in connection with LRC/ Civil Case Number 3957P. This is bolstered by the absence of any criminal case filed by Petitioner Republic against Solicitor Carriazo, whom the former accuses of fraudulent conspiracy with the private respondents in LRC/ Civil Case Number 3957P. Moreover, despite being notified of the hearing on the Tallano Acop petition, the OSG failed to appear at said hearing or file any opposition on the petition. For another, Private Respondent J.M. Tallano claims that the Republic allegedly initiated a compromise agreement with his predecessors in interest, which culminated in the issuance and approval of the alleged decision with compromise agreement dated February 4, 1972. 160 said decision with compromise agreement became final and executory, as well as executed more than 30 years ago. Second, Private Respondent J.M. Tallano negates the alleged lack of jurisdiction of Respondent Court in issuing the assailed decisions order/writs and other documents in LRC/ Civil Case Number 3957P. He argues that the 21 volumes of records in LRC/ Civil Case Number 3957P, brought during the hearing on April 7, 2006, and certified as complete by Ricardo R. Adolfo, branch clerk of Court of Respondent Court, are positive proof that the latter. 159 see a GRSP number 70,014, Rollo, Volume 1I, page 1295. 160 Supra, Note 6. See a GRSP number 70,014 and 104,604 decision. Page 37. Court had jurisdiction to hear and decide said case. For Private Respondent J.M. Tallano, said 21 volumes are assumed to be valid and legal, unless shown to be spurious, and should prevail over the affidavits of employees of the OSG, who can be easily manipulated by the latter. Speaking of the 21 volumes, Private Respondent J.M. Tallano states in his memorandum. 1. 21 volumes of court documents encompassing thousands of pages involving minute details cannot be a product of fabrication even by the most brilliant mind this country can ever produce. It cannot be a work of fiction, because it defies even the deftly written works of James Joyce such as Ulysses or the mainstream consciousness style of Marcel Proust in Remembrance of Things Past. This is so, because the Tallano story deals with facts not fiction. 161 underscoring supplied. Then, narrating his story, Private Respondent J.M. Tallano avers that long before the Spaniards came to the Philippines, it was already ruled by a certain King Luis Antiguan Tallano, who incidentally, was not just his ascendant, but was also the father of Raja Lapu-Lapu and Raja Solomon. Allegedly, when the British defeated the Spaniards in 1764, the British royal government issued Royal Decree Protocol 01-4, amending the property rights of King Philip of Spain over the Philippines, and granting ownership of the Philippine archipelago to the Taji and Tallano clans. Allegedly, after the signing of the peace accord between the Spanish and British governments, the Queen of Spain recognized the property rights of the Taji and Tallano clans over the Philippine archipelago, based on the Mora Law. 162. Tracing the origins of his title, Private Respondent J.M. Tallano further claims that when the Philippines was sold in the Treaty of Paris, it was his predecessor in interest, Don Esteban Benitez Tallano, who paid the $20 million in gold coins to the Spanish government. Allegedly, by virtue of said payment. 161 See GRSP number 70014, Rollo, volume 11th, page 7830. 162 ID at 7836 to 7837. The facts are culled from the true story of the Tallano Taller estate, appended as an X1 PJMT of Private Respondent J.M. Tallano's memorandum. See a GRSP number 70014 and 104604 decision. Page 38. The Aficionado Cabaldo recognized and affirmed Royal Decree Protocol 01-4 and the same was registered as titulo de comprar in favor of Prince Lacan Acuna Ulrich Boquia Tallano, another of his predecessors in interest. 163. When the K.O.R.A.N system of titling was introduced in the Philippines, with the passage of Act No. 496, land registration proceedings were allegedly undertaken by the Tallano clan. On October 3, 1904, original certificate of title 01-4 OCT 01-4 was allegedly issued, affirming their ownership and title over the Philippine archipelago. This affirmation was allegedly replicated with the passage of Cadastral Act 2259 of 1913, 164. Incidentally, Private Respondent J.M. Tallano claims that OCT 01-4 is the oldest title issued in the Philippines, from which title to transfer certificates of title TCT were supposedly derived, namely TCT number 498 and TCT number 408, both issued on June 7, 1932. In the names of Esteban Benitez Tallano and Gregorio Madrigal Acop, respectively. 165. Finally, Private Respondent J.M. Tallano cites Section 3M, N, and O of Rule 131, 166 and Section 5H of Rule 135,167 of the Rules of Court, arguing that doubts as to the regularity of 163 See GRSP number 70014, Rollo, volume 11th, page 7837. 164 ID. 165 ID at 7841. 166 Section 3. Disputable presumptions. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. N. That official duty has been regularly performed. N. That a court, or judge acting as such, whether in the Philippines or elsewhere, was acting in the lawful exercise of jurisdiction. O. That all the matters within an issue, raised in a case were laid before the court, and passed upon by it, and in like manner, that all matters raised within an issue raised in a dispute submitted for arbitration were laid before the arbitrators, and passed upon by them. 167 Section 5. Inherent powers of courts. Every court shall have the power to authorize a copy of a lost, or destroyed pleading, or other paper to be filed and used instead of the original, and to restore, and supply deficiencies in its records and proceedings. KG.R. SP number 70014 and 104604 decision. Page 39. Proceedings in respondent court should be resolved in his favor, and that courts have the inherent power to authorize copies of lost records to be used instead of the original, to supply deficiencies in their proceedings. Private respondent says of Acopiado's arguments. for the heirs of Acopiado, the Republic's 4-year period, to file a petition for annulment of judgment has long prescribed, more so since such recourse is available only where the ordinary remedies of new trial, appeal, or petition for review are no longer available through no fault of petitioner. They suggest that if anything, the Republic's invocation of either grounds of lack of jurisdiction and/or extrinsic fraud is already barred by laches. The following are allegedly antithetical to the Republic's arguments. First, the OSG was supposedly furnished a copy of an alleged entry of judgment dated February 4, 1972, which became final and executory on April 4, 1972. Second, the Republic, allegedly represented by no less than then President Ferdinand E. Marcos and then Solicitor General Felix Macleod, entered into a decision with compromise agreement dated February 4, 1972 168 with Gregorio Madrigal Acopiado. Third, Solicitor Carriazo made an admission in the hearing of July 4, 1997 that the OSG received a copy of the decision dated November 4, 1975. 169 and 4th. The OSG allegedly received a copy of the order dated July 7, 1997 on July 16, 1997, through its representative, a certain Bartolome Villarreal, as evidenced by a registry return card of even date. Besides, unlike private respondent J.M. Tallano, who claims practically the entire archipelago, the heirs of Acopiado aver that they only lay claim to 29,151.768 hectares of land as embodied in TCT number 408. This land was allegedly awarded by 168 Supra, Note 6. 169 Supra, Note 8. See a GRSP number 70,014 and 104,604 decision. Page 40. The Supreme Court in RG 571, 170 and 1911, to their predecessor in interest, Gregorio Madrigal Acopiado. Relying on Palomo vs. Court of Appeals, 171, the heirs of Acopiado assert that in the beginning, all lands in the whole archipelago were privately owned. 172, tracing their entitlement to a substantial portion of the Philippines, they claim that on January 7, 1864, land title over the archipelago was issued by the Spanish government for, and in the name of Don Hermogenes Antonio Rodriguez, under OCT number 01-4, which allegedly embraced 7,134 islands of around 503,877 square nautical miles 173. In 1891, King Alfonso XII allegedly ordered the grant of Royal Decree No. 01-4 Protocol to Chulo de Propriedad de Terrenos of 1891 to Don Hermogenes Antonio Rodriguez and Don Miguel Antonio Rodriguez 174 according to the heirs of Acopiado, said OCT No. 01-4 underwent appropriate judicial process requirement under the Mora Law or the Royal Decree of February 17, 175 1894, 176. 170 no authentic copy of such document exists. 171 GR number 95608, January 21, 1997, 266 SCRA 392. 170 to the foregoing interpretation of the heirs of Acopiado may have been a misreading of Palomo vs. Court of Appeals, Supra. No categorical statement to that effect was made therein. However, the following excerpt from said case may be instructive. The Philippines passed to the Spanish crown by discovery and conquest in the 16th century. Before the Treaty of Paris in April 11, 1899, lands, whether agricultural, mineral, or forest, were under the exclusive patrimony and dominion of the Spanish crown. Hence, private ownership of land could only be acquired through royal concessions which were documented in various forms, such as 1. Titulo real or royal grant, 2. Concession especial or special grant, 3. Titulo de comprar or title by purchase, and 4. Information possessoria or possessory information title obtained under the Spanish mortgage law, or under the Royal Decree of January 26, 1889. 173 CRGRSP number 70014, Rollo, volume 11th, page 7775. 174 note, that in the account of the heirs of Acopiado, the issuance of an alleged OCT number 01-4 in 1864 preceded the issuance of a supposed royal decree number 01-4 protocol, in 1891. 175 should be February 13th, 1894. 176 CRGRSP number 70014, Rollo, volume 11th, page 7775. CRGRSP number 70014 and 104,604 decision. Page 41. Subsequently, Don Hermogenes Antonio Rodriguez obtained an adjustment title over 4 parcels of land covered by OCT number 01-4. Allegedly, on October 3, 1904, Don Hermogenes Antonio Rodriguez's ownership registration of the subject lands was settled by the Land Registration Court under CLRO case number 475. On October 4, 1904, OCT number 01-4 allegedly completed its legalization and registration under RA number 496, 177 of November 6, 1902, which also allegedly made said title incontrovertible 178. On October 14, 1913, Don Hermogenes Antonio Rodriguez and Don Miguel Antonio Rodriguez allegedly executed a deed of absolute sale, transferring all of their land holdings covered by Royal Decree number 01-4 in favor of Gregorio Madrigal Acopiado, father of A.M. Acopiado 179 on March 14, 1914. Plans for the entire Philippine archipelago were allegedly approved as Plan 269 and Plan 2-668 in favor of Gregorio Madrigal Acopiado and A.M. Acopiado, 180 the heirs of Acopiado's predecessors in interest. Eventually, with OCT number 01-4 as the mother title, 4 derivative titles were issued on the following dates, namely TCT number 408 on June 7, 1932, TCT number 498 on August 10, 1934, TCT number 407 on July 5, 1936, and TCT number 409 on April 20, 1937. CRGRSP number 104,604. Petitioners Solis, et al. S arguments. Petitioners Solis, et al. Contend that respondents Myra, LTO and the Pasay City government must be punished with indirect contempt for deliberately violating the writ of preliminary. 177 The heirs of Acopiado must be referring to Act No. 496, otherwise known as the Land Registration Act of November 6, 1902, instead of RA No. 496, which is an act to prohibit labor on Sunday, Christmas Day, New Year's Day, Holy Thursday, and Good Friday. 178 CRGRSP No. 70014, Rollo, Volume 11th, page 7776. 179 ID at 7781. 180 ID. CRGRSP number 70014 and 104,604 decision. Page 42. Injunction this court has issued on June 25, 2002 in K.O.R.A.N. SP number 70014. As basis, Petitioner Salas, et al. Cite Sex 3b and d of Rule 71 of the Rules of Court, thus. Section 3. Indirect contempt to be punished after charge and hearing. A person guilty of any of the following acts may be punished for indirect contempt. B. Disobedience of, or resistance to a lawful writ, process, order, or judgment of a court, including the act of a person who, after being dispossessed or ejected from any real property by the judgment or process of any court of competent jurisdiction, enters or attempts, or induces another to enter into war upon such real property, for the purpose of executing acts of ownership or possession, or in any manner disturbs the possession given to the person adjudged to be entitled thereto. XXX. d. Any improper conduct tending, directly or indirectly, to impede, obstruct, or degrade the administration of justice. Specifically, Petitioner Salas et al. Reprove the following acts of respondents MIAA, for sending notices to vacate to some residents of Pasay City, and for entering into a memorandum of agreement with the LTO in respect of the subject real property. LTO, for sending notices to vacate to the PNP traffic management group stationed in Pasay City, and for demolishing, and subsequently building structures in the LTO compound, and the Pasay City government, for facilitating the issuance of a building permit in favor of the LTO. See a GRSP number 70,014 and 104,604 decision. Page 43. Respondents MIAAs and LTO's arguments. Respondents MIAA and LTO contend that their challenged acts have no nexus whatsoever with the writ of preliminary injunction issued in SIA GRSP number 70,014, 181. In fact, they claim that their acts are consistent with their property rights, and with their being instrumentalities of the Republic, which filed SIA GRSP number 70,014. Respondents MIAA and LTO emphasize that, since they have not been named respondents in SIA GRSP number 70,014, and since the subject writ of preliminary injunction relates solely to the enforcement of the orders dated July 7, 1997, 182 July 11, 2001, 183 and October 8, 2001, 184 in said case, then they cannot be held liable for indirect contempt. 185. Respondent Pasay City government's arguments. Echoing the line of reasoning of its fellow respondents, the Pasay City government argues that, since it is not among those specifically enjoined by the writ of preliminary injunction issued in SIA GRSP number 70,014, it cannot be cited for indirect contempt. Succinctly, respondent Pasay City government posits that a person cannot be held liable for contempt in violation of an injunction, or of any judicial order, unless the act which is forbidden or required to be done, is clearly and exactly defined, so as to leave no reasonable doubt or uncertainty as to what specific act or thing is forbidden or required. 186. This court's ruling. We resolve the issues in seriatim. 181 Supra, Note 116. 182 Supra, Note 18. 183 Supra, Note 19. 184 Supra, Note 20. 185 SIA GRSP number 104,604, Rollo, pages 302 to 314. 186 ID at 266 to 278. SIA GRSP number 70,014 and 104,604 decision. Page 44. KG.R. SP number 70,014. First issue. Whether or not respondent court acquired jurisdiction over the Del Rio petition and or the Tallano Acop petition. We rule in the negative. At the outset, we note that there are not just two, but in fact, three petitions for a constitution involved in SIA GRSP number 70,014. The first is the Del Rio petition, while the second is the Tallano Acop petition. Meanwhile, the third petition for a constitution pertains to the original LRC/civil case number 3957P, the records of which are the objects of reconstitution of the Del Rio petition and the Tallano Acop petition. We are behoved to make such distinctions, because these are crucial in determining the applicable laws to the instant case. In turn, these applicable laws shall provide the threshold premise on the issue of acquisition of jurisdiction of respondent court. To recapitulate, the Del Rio petition is a petition for a constitution of the alleged decision dated November 4, 1975, 187, which included in its lengthy dispositive portion, a directive to the Register of Deeds of the province of Resol, to reconstitute administratively the lost owners and duplicate copies of TCT number 408, for and in the name of Gregorio Madrigal Acopiado, and to carry over thereon the annotations at the back of said title. On the other hand, the Tallano Acop petition sought the reconstitution of A. An alleged decision with compromise agreement dated February 4th, 1972. B. An alleged clarificatory order dated March 21st, 1974. C. An alleged clarificatory decision dated January 19th, 1976. D. An alleged third alias writ of execution, possession, and demolition dated May 23rd, 1989. E. All other pertinent documents connected to LRC/civil case number 3957P, inclusive of TCT number T408. Supra, Note 8. SEA GRSP number 70014 and 104604 decision. Page 45. Meanwhile, the original LRC/civil case number 3957P refers to the original reconstitution case, the 2121 volumes of which were subpoenaed by this court for examination by the parties in SEA GRSP number 70014. Both the Del Rio petition and the Tallano Acop petition overtly sought to reconstitute judicial records in LRC/civil case number 3957P, which were burned during the fire which gutted the Pasay City Hall on January 18, 1992. However, a perspicacious examination of both petitions for reconstitution show that these petitions do not merely desire the reconstitution of decisions, orders/writs/other court records relating to LRC/civil case number 3957P. Rather, both the Del Rio petition and the Tallano Acop petition also seek the reconstitution of certain alleged TCTs implicitly in the former petition, as a consequence of the reconstitution of the decision dated November 4, 1975, and explicitly in the latter petition, as evident in its prayer. Thus, to determine whether or not respondent court acquired jurisdiction over the Del Rio petition and the Tallano Acop petition, we need to look into both Act number 3110, 188 and RA number 26, 189. The pertinent portions of Act number 3110 provide: Section 1. As soon as practicable after the occurrence of any fire or other public calamity resulting in the loss of all, or part of the records of judicial proceedings on file in the office of the clerk of a court of first instance, said officer shall send a notice, by registered mail to the Secretary of Justice, the Attorney General, the Director of Lands, the Chief of the General Land Registration Office, the Clerk of the Supreme Court, the Judge of the Province, the Register of Deeds of the Province, the Provincial Fiscal, and all lawyers who may be interested, stating the date on which such fire or public calamity occurred, and whether the loss or destruction was total or 188 Supra, Note 126. 189 Supra, Note 31. SEA GRSP number 70014 and 104604 decision. Page 46. Partial, and giving a brief list of the proceedings not affected in case the loss or destruction was partial. Section 2. Upon receipt of the notice mentioned in the preceding section, the court shall issue or cause to be issued a general notice which shall be addressed and sent by registered mail to the lawyers and officers mentioned in the preceding section, and to such other persons as might be interested, advising them of the destruction of the records, with a brief list of the proceedings not affected in case the destruction was partial, and of the time fixed by this act for the reconstitution of the destroyed records. The notice shall also be published in the official gazette, and in one of the newspapers most widely read in the province, once a week, for 4 consecutive weeks. Section 3. The parties to civil cases, or their counsels, shall appear and file, within 30 days, after having been notified in accordance with the next preceding section, an application for the reconstitution of the records in which they are interested, and the clerk of court, upon receiving such application, shall send notice to all parties interested, or their counsels, of the day, hour, and place when the court will proceed to the reconstitution, requesting them to present, on said day and hour, and at said place, all copies of motions, decrees, orders, and other documents in their possession, having reference to the record or records to be reconstituted. XXX. Section 29. In case the parties interested in a destroyed record fail to petition for the reconstitution thereof within the 6 months next following the date in which they were given notice in accordance with section 2 hereof, they shall be understood to have waived the reconstitution, and may file their respective actions anew without being entitled to claim the benefits of section 31-190 hereof. Emphasis and underscoring supplied. 190 for all legal effects, the time that has elapsed from the institution of the destroyed record until the date when its reconstitution was declared impossible, shall not be counted against the interested party or his heirs and other successors in interest. See a GRSP number 70,014 and 104,604 decision. Page 47. It has been held that the requirements set forth in this act are mandatory and jurisdictional before a court may take cognizance of the petition for reconstitution. Failure to comply with its express provisions shall vitiate the reconstitution proceedings and shall render the order declaring the records reconstituted ineffective. 191. In this case, there were manifest and fatal breaches of the requirements laid out in Act No. 3110 and RA No. 26. For instance, the records of both the Del Rio petition and the Tallano Acop petition do not show that the required notices under Secs 1 and 2 have been issued. In fact, if only to emphasize such non-compliance, even private respondent J.M. Tallano alleged the following in the Tallano Acop petition. 12. Neither intervenors Don Anacleto Madrigal Acop and / or Julian M. Tallano, their common administrator Don Prince Julian M. Tallano, or their counsel of record, were notified of the destruction / burning of the records of the case at bar as required in sections 1 and 2 of RA No. 3110. It was only very recently that the judicial administrator Don Prince Julian M. Tallano and his attorney in fact Romeo Servants Campus have ascertained that the records of the present case were totally destroyed by the January 18, 1992 fire 192 supplied. Moreover, even assuming that notices have been sent, these have not been published in the official gazette, as mandated by law. Indeed, while it appears that the Tallano Acop petition was published in the Philippine Reporter, no proof was adduced that it was published in the official gazette, the only newspaper in which publication is regarded as compliance with the law. We emphasize that the use in Act No. 3110 of the imperative shall dash instead of the permissive may dash, and the conjunctive, and dash instead of the disjunctive, or dash in prescribing the required manner and form of publication of the notices cannot be ignored. 191 Reyes vs. Pexon, GR number 502879, April 21, 1950, 86 Phil 181. 192 SEA GRSP number 70014, Rollo, Volume 1I, page 1038. SEA GRSP number 70014 and 104,604 decision. Page 48. Attorney Jacoba, duly seconded by Attorney Emitter, contends that the requirements under Act No. 3110 do not apply since said Act only applies to pending cases, whereas LRC/civil case is already a finished case. This contention was made despite the following statement in the Tallano Acop petition by private respondent J.M. Tallano-Um attorney. Jacoba represents 13. The case at bar was still pending and active when the January 18, 1992 fire broke out, and continues to be active and pending up to the present, since the decision with compromise agreement dated February 4, 1972 together with the clarificatory order of March 1, 1974. And the clarificatory decision of January 19, 1976 have not yet been fully executed, emphasis and implemented and satisfied to date. 193 underscoring supplied. Their inconsistent declarations notwithstanding, we believe that there is no need to make such distinction following Feria vs. Court of Appeals, et al. 194 quoting Erlanger and Gallina vs. Ixcond, which has squarely settled the issue. 195 we quote. Judicial records are subject to reconstitution without exception, whether they refer to pending cases or finished cases. There is no sense in limiting reconstitution to pending cases. Finished cases are just as important as pending ones, as evidence of rights and obligations finally adjudicated. Underscoring and emphasis supplied. More to the point, if Act Number 3110 did not intend reconstitution of finished cases, the existence of Section 7 thereof, specifically referring to decided civil cases, would have been mere surplusage. Said section states, Section 7 If a civil case has already been decided, the decision shall be reconstituted by means of an authentic copy. In case an authentic copy cannot be found, the court shall make a new decision, as if the case had never been decided. Underscoring supplied. 193 CA GRSP number 70014, Rollo, Volume 2, page 1038. 194 GR number 122954, February 15th, 2000, 325 SCRA 525. 195 GR number L-4792-95, September 30th, 1953, 93 FIL 894. SEA GRSP number 70014 and 104604 decision. Page 49. We now proceed to examine RA number 26. The following provisions thereof are pertinent. Section 12 Petitions for a Constitution from sources enumerated in Sections 2C, 2D, 2E, 2F, 3C, 3D, 3E, and /or 3F of this Act, shall be filed with the proper court of first instance, by the registered donor, his assigns, or any person having an interest in the property. The petition shall state or contain, among other things, the following. The owner's duplicate copy of the certificate of title had been lost or destroyed. B. That no co-owners, mortgagees, or lessees duplicate had been issued, or, if any had been issued, the same had been lost or destroyed. C. The location, area, and boundaries of the property. D. The nature and description of the buildings or improvements, if any, which do not belong to the owner of the land, and the names and addresses of the owners of such buildings or improvements. E. The names and addresses of the occupants or persons in possession of the property, of the owners of the adjoining properties and all persons who may have an interest in the property. F. A detailed description of the encumbrances, if any, affecting the property, and G. A statement that no deeds or other instruments affecting the property have been presented for registration, or, if there be any, the registration thereof has not been accomplished, as yet. All the documents, or authenticated copies thereof, to be introduced in evidence in support of the petition for a constitution shall be attached thereto, and filed with the same, provided that in case the reconstitution is to be made exclusively from sources enumerated in Section 2F or 3F of this Act, the petition shall be further accompanied with a plan and technical description of the property duly approved by the Chief of the General Land Registration Office, or with a certified copy of the description taken from a prior certificate of title covering the same property. Section 13 The court shall cause a notice of the petition, filed under the preceding section, to be published, at the expense of the petitioner, twice in successive issues of the Official Gazette, and to be posted on the main entrance of the provincial building, and of the municipal building of the same municipality or city in which the land is situated, at least 30 days prior to the date of hearing. The court shall likewise cause a copy of the notice to be sent, by registered mail or otherwise, at the expense of the petitioner, to every person named therein whose address is known, at least 30 days prior to the date of. See a GRSP number 70014 and 104604 decision. Page 50. Hearing. Said notice shall state, among other things, the number of the lost, or destroyed certificate of title, if known, the name of the registered owner, the names of the occupants or persons in possession of the property, the owners of the adjoining properties and all other interested parties, the location, area, and boundaries of the property, and the date on which all persons having any interest therein must appeal, and file their claim or objections to the petition. The petitioner shall, at the hearing, submit proof of the publication, posting, and service of the notice as directed by the court. Underscoring supplied. Like Act Number 3110, compliance with the foregoing provisions is mandatory and jurisdictional. This is because in all cases where the authority to proceed is conferred by statute and the manner of obtaining jurisdiction is mandatory, the same must be strictly complied with, or the proceedings will be utterly void. 196 In the case of RA number 26, strict compliance is designed to prevent the misuse and abuse of reconstitution proceedings as a means of divesting a property owner of title to his property. Thus, it has been held that the requirements in section 12 of RA number 26 on the contents of a petition for reconstitution of title, and in section 13 of the same act on publication, posting, and sending by mail are mandatory and jurisdictional, non-observance of which fatally affects the whole proceedings in all its aspects. 197 As such, the court upon which the petition for reconstitution of title is filed is duty-bound to examine thoroughly said petition and to review the record and the legal provisions laying down the germane jurisdictional requirements. 198 While it is true that courts have the inherent power to reconstitute judicial records, it does not mean that they can exercise this power at will in disregard of the reasonable requirements of the law on the same matter. 199 196 Ordus vs. Court of Appeals, GR number 118836, March 21, 1997, 270 SCRA 328. 197 C. Ortegas & Co. Limited. Partnership vs. Velasco, GR number 109645, July 25, 1994. 234 SCRA 455. 198 Bernardo vs. Court of Appeals, GR number 111715 and 112876, June 8, 2000, 333 SCRA 135. 199 Commodities Sales Corporation vs. Lawsuit Busco Incorporated, GR number 55952, March 31, 1989, 171 SCRA 509. SEA GRSP number 70014 and 104604 decision. Page 51. In this case, respondent court, again, did not acquire jurisdiction over the Del Rio petition and the Tallano Acop petition, because both failed to comply with the provisions of RA number 26. The records will show, among others, that 1. The jurisdictional averments of both petitions are woefully inadequate. 2. The notices have not been published in the official gazette, and 3. The notices have not been sent to all persons identified by law to receive the same. Since respondent court did not acquire jurisdiction over the Del Rio petition and the Tallano Acop petition, it follows that it had no authority to issue the orders dated July 7, 1997, 200 July 11, 2001, 201 and October 8, 2001, 202 which ordered the reconstitution of the assailed decisions orders/writs/other documents. To erase whatever lingering doubts on this case, we also rule that jurisdiction over the original LRC/civil case number 3957P was not acquired either. Suffice it to say that the presumption of regularity in the reconstitution of records of LRC/civil case number 3957P was successfully overcome when the records of said records were examined on April 7, 2002. We quote the following exchange between ASG Laragan and private respondents counsel's attorney Jacoba and attorney Emeta during said examination, thus. Attorney Laragan, I would like to manifest, Your Honor, that upon examination of this volume 1 of the record of civil case number 3957P, consisting of 182 pages, there is nothing contained therein the following notice sent by the office of the clerk of court to the officials, mentioned in section 1 of Act number 3110, informing them of the fire or public calamity that resulted in the total or partial destruction of the records of civil case number 3957P. Number 2, the lower court did not issue or send a general notice to the officials, mentioned in the same section 1 of Act number 200 Supra, Note 18. 201 Supra, Note 19. 202 Supra, Note 20. SEA GRSP number 70014 and 104604 decision. Page 52. 3110 as well as to all interested parties advising them of the destruction of the records in the prescribed period for each reconstitution. Number 3. The general notice referred to in the preceding paragraph was not published in the official gazette, and in newspapers widely read in Pasay City once a week, for 4 consecutive weeks. Number 4. There was no posting in conspicuous public places of the notice of the initial hearing relative to the reconstitution of the alleged OCT number T01-4 and TCT numbers 408 and 498. Number 5. There was no notice to the occupants of the properties covered by the alleged and the adjoining owners. And lastly, the notice, if there was any, was not published in the official gazette. Attorney Servants 203. Any comment? Attorney Jacoba. We will state again, and repeat without tiring, that those requirements are not necessary for judicial records, because these were already terminated cases, Your Honor. Attorney Servants. Attorney Emitter. Attorney Emitter. I adopt the same manifestation of counsel, Your Honor. 204 underscoring supplied. The absence of the requisites pointed out by ASG Laragan have been highlighted in all 21 volumes of LRC/Civil Case number 3957P, and repeated manifestations to that effect have been made. The non-compliance by all the petitions for a constitution namely, the Del Rio petition, the Tallano Acop petition, and the original petition for a constitution with the requirements of Act number 3110 and RA number 26 means that the questioned decisions orders/writs/other documents emanating from and reconstituted in all the petitions for a constitution are void. 203 Then Division Clerk of Court, 2nd Division, Court of Appeals. 204 CRSP number 70014, Rollo, Volume 9, pages 5746 to 5747, TSN. April 7, 2006, pages 18 to 19. SEA GRSP number 70014 and 104604 decision. Pages 53. Basic is the doctrine that a void judgment or order has no legal and binding effect, force, or efficacy for any purpose. In contemplation of law, it is non-existent. 205 It never requires finality, and any action to declare its nullity does not prescribe. 206 In fact, it is not even necessary to take any steps to vacate or avoid such judgment or final order, it may simply be ignored. 207. Second issue whether or not the decisions orders/writs/other documents issued in connection with LRC/Civil Case number 3957P are valid and enforceable. We rule in the negative. The assailed decisions orders/writs/ and other documents are apocryphal, to say the least. Even on their faces, they are, in the words of the OSG, replete with statements and representations that are patently ridiculous, absurd, and preposterous. If we may say so, the web of bafflements would have been amusing were it not so brazenly calculated to trifle with the dignity of the judicial process. In our jurisdiction, there are matters of which we must take judicial notice and concepts of which we may take judicial notice. Thus, Sects 1 and 2 of Rule 129 of the Rules of Court provide. Section 1 Judicial Notice. When mandatory, a court shall take judicial notice, without the introduction of evidence, of the existence and territorial extent of states, their political history, forms of government and symbols of nationality. The 205 People vs. Court of Appeals, GR number 144332, June 10, 2004, 431 SCRA 610. See also Carlotto vs. Commission on Elections, GR number 174155. January 24, 2007. 512 SCRA 542, where it was held that a void judgment can never be validly executed. 206 National Housing Authority vs. Commission on the Settlement of Land Problems, GR number 142601, October 23, 2006, 505 SCRA 38. 207 Buvera, et al. Versus the Honorable 4th Division of the Sandigan Bayan, et al. GR numbers 138,792 to 138,804, March 31st, 2005, 454 SCRA 372. SEA GRSP number 70,014 and 104,604 decision. Page 54. Law of Nations, the Admiralty and Maritime Courts of the World and their seals, the political constitution and history of the Philippines, the official acts of the legislative, executive and judicial departments of the Philippines, the laws of nature, the measure of time, and the geographical divisions. Section 2 Judicial Notice. When discretionary a court may take judicial notice of matters which are of public knowledge, or are capable of unquestionable demonstration, or ought to be known to judges, because of their judicial functions. Judicial notice, in its appropriate field, displaces evidence since as it stands for proof, it fulfills the object which evidence is for designed to fulfill, and makes evidence unnecessary. 208 Instance. Courts have always, and without exception, taken judicial cognizance without proof of those great historical events which have affected the destiny of our nation, or of other nations. The grounds of their notice are the common knowledge and open frame of such events 209 and the assailed decisions in the instant case. There are allegations of fact, the falsity of which we take judicial notice. For example, in the alleged decision with compromise agreement dated February 4, 1972 210 which the Republic allegedly initiated, and to which it was supposedly a party, declarations to the effect that private respondent J.M. Tallano's alleged forebear, a certain King Louis Antigian, lived to be 270 years old 211. And that the latter allegedly sired both Raja. 208 Chiala de Luca vs Hartford Park, 94 Khan 7, 107A 611, as cited in Francisco, Ricardo J. Evidence Rules of Court in the Philippines, 3rd edition, 1996, page 22. 209, 1 Jones on Evidence, section 435. 210 The following excerpt, unedited to retain the tenor of the text, is culled from the decision with compromise agreement dated February 4, 1970 to the second eldest son of King Louis Antigian was named Raja Solomon, the one who controlled the entire area of Manila and its suburbs including the provinces of Rizal, Cavite, Batangas, Laguna, and the Calaria province now Quezon. Times and Rajalapilapu, the eldest son of King Louis Antigian, took over the area of Mactan Island. Under K.O.R.A.N supplied. 211 The following excerpt, unedited to retain the tenor of the text, is culled from the decision with compromise agreement dated February 4, 1970 to the noble King Louis Antigian, almost 9 months after the issuance of the declaration of the said treaty, died in peace with happiness in heart could be reflected therein on. KG.R. SP number 70,014 and 104,604 decision. Page 55. Solomon and Rajalapu, making both brothers. The same decision also stated that prior to 1761, the Spanish government had allegedly mortgaged the Philippine archipelago to the US government, even when the United States of America declared its independence from the British Empire only in 1776, 212. The decision dated November 4, 1975 213 is not spared from fantastic claims either. We quote the following glaring and bizarre inconsistencies in said decision, as observed by the Republic, to wit. XXXT alleged decision dated November 4, 1975 states that, based on the records, the instant case originated from a petition for a conveyance which was filed on January 4, 1972 and which was later succeeded by a second amended petition filed on February 4, 1972 in the name of Gregorio Madrigal Acopiado. Going over the record of the case, it appears the case originated from a petition of reconveyance which was filed on January 4, 1972, and later the plaintiff filed a second amended petition on February 4, 1972, which was recorded as petition for annulment and quieting of titles, reconveyance with reconstitution of lost owners. and duplicate copies of TCT 408 administratively in accordance with Republic Act 26-4, and in the name of Don Gregorio Madrigal Acopiado in dishonorable. December 17th, 1764, exactly at 270 years of age upon learning the positive fruits of his efforts, which has the issuance of land title over the archipelago in his honor, issued by the British government embracing 7,134 islands embracing around 503,877 square nautical miles under OCT number T-01-044, and in the name of his grandson, Prince Lacan to Julian on December 17th, 1764, and later to 16-years-old Prince Julian Macleod Tallano in 1864. Underscoring supplied. 212. The following excerpt, unedited to retain the tenor of the text, is culled from the decision with compromise agreement dated February 4th, 1972 to augment the efforts in rebellion successfully. Prince Julian Macleod to Guillen Tallano times redeemed the island from the US government in the amount of $20 million mortgaged by Spanish government, and sought succor from British Empire in the year 1761 that resulted into a military siege over the islands by the British Dominion in honor of the noble clan. The Tajian Tallano family had resulted for a period of 7 years British occupation in the archipelago. Underscoring supplied. 213 Supra, Note 8. See a GRSP number 70,014 and 104,604 decision. Page 56. Court, 7th Judicial District, Branch 28, CFI, Pasay City, lodged under civil case number 3957P, against the respondents plaintiffs, and to all whom it may concern. Pages 9 to 10. Emphasis supplied. The fact that the alleged decision with compromise agreement dated February 4th, 1972, inexplicably coincides with the exact date of the filing of the alleged amended petition simply betrays reason and logic, thereby lending credence to the fact that these alleged decisions are indeed spurious. What is more, the alleged decision with compromise agreement dated February 4th, 1972 involved a certain Gregorio Madrigal Acop, while the alleged decision dated March 4th, 1975 involved a certain Gregorio Madrigal Acopiado 214 underscoring supplied. The whimsical tenor of the questioned decisions order/writ/other documents has been carried over to private respondents' memoranda. In fact, we have observed that in their memorandum, 215 the heirs of Acopiado have weaved a narration of alleged facts from the various assailed decisions and orders, the spuriousness of which we have already taken judicial notice. Moreover, we note that even as they beg to be differentiated from the preposterous claims of private respondent J.M. Tallano, the heirs of Acopiado heavily rely on the validity of the alleged decision with compromise agreement dated February 4th, 1972, 216 which has been introduced by private respondent J.M. Tallano. We feel no need to refute, lest we dignify, the fascinating accounts of alternative history of private respondents J.M. Tallano and heirs of Acopiado, since the inconsistencies and absurdity of their claims speak for themselves. For being spurious on their faces, said decisions order/writ/other documents are void. Consequently, said void decisions order/writ/other documents are not entitled to enforcement and are 214 see a GRSP number 70,014, Rollo, volume times, pages 7376 to 7377. 215 Supra, notes 138 and 140. 216 Supra, note 6. See a GRSP number 70,014 and 104,604 decision. Pages 57. Ordinarily, no protection to those who seek to enforce the same. All proceedings founded on the void judgment are themselves regarded as invalid. 217. And yet, even assuming that the assailed decisions order/writ/other documents are not spurious on their faces and therefore valid, still, these can no longer be executed on account of prescription. Section 6 of Rule 39 of the Rules of Court is clear. Section 6. execution by motion, or by independent action. A final and executory judgment or order may be executed on motion within 5 years from the date of its entry. After the lapse of such time, and before it is barred by the statute of limitations, a judgment may be enforced by action. The revived judgment may also be enforced by motion within 5 years from the date of its entry, and thereafter by action, before it is barred by the statute of limitations. In the instant case, the decisions order/writ/other documents date as far back as the early 1970s to the late 1980s. Without need of elaboration, these dates are simply way beyond the prescriptive period allowed by law for executing a judgment, either by motion or by independent action. Third issue, whether or not petitioner republic is estopped and or barred by laches from filing the instant petition. We rule in the negative. Much has been said about the manifestation made by Solicitor Carriazo on the hearing on the Del Rio petition on July 4, 1997. For purposes of our discussion, we quote Solicitor Carriazo's controversial statement, to appreciate its full import. Solicitor Carriazo: we have examined the documents that were attached to the petition for reconstitution. 217 Metropolitan Water Works and Sewerage System vs. Sisson, GR.L 40309, August 31, 1983, 124 SCRA 394, citing 31 Am. J. 91-92. SEA GRSP number 70014 and 104604 decision. Page 58. And we find them to be accurate copies of the documents that were received by the Office of the Solicitor General. It is sick being the case, we offer no objection to the reconstitution of the lost or burnt documents 218. To our mind, Solicitor Carriazo's manifestation is clear on two respects: first, that he has examined the documents attached to the petition, and second, that these documents are accurate copies of the documents received by the OSG. However, we note that no mention was made as to the date of receipt of said documents. Private respondents J.N. Tallano, A.M. Acop, and heirs of Acop conclude that Solicitor Carriazo's manifestation can only mean that the subject documents were received by the OSG within a reasonable time from their promulgation, that is, circa 1970s and 1980s. The OSG, meanwhile, states through the affidavits of former Assistant Solicitor General Nestor Balasillo, 219 ASG Balasillo and OCA Division Chief Rosalina Shiangson, 220, that prior to their receipt of the Del Rio petition on June 30, 1997, it had no records whatsoever of civil case number 3957P, and that the alleged decisions order/writ/other documents sought to be reconstituted were received by the OSG only after June 27, 2007, 221. Thus we are faced with the situation where we have one group which asserts presumption of regularity of proceedings and another group which negates said assertion. Fortunately, we can rest on the established doctrine that the Republic is not estopped by mistake or error on the part of its officials or agents, of which Solicitor Carriazo is one. 222. 218 SEA GRSP number 70014, Rollo, Volume 2, page 1195. 219 SEA GRSP number 70014, Rollo, Volume 1, pages 573 to 585, Annexo of OSG petition. 220 SEA GRSP number 70014, Rollo, Volume 2, pages 1211 to 1215. Annex FFFF of OSG petition. 221 SEA GRSP number 70014, Rollo, Volume 1, page 77 and Volume 2, page 1214. 220 to Luciano vs. Estrella, GR number 5031622, August 31st, 1970, 34 SCRA 769. SEA GRSP number 70014 and 104604 decision. Page 59. Simply, the doctrine of estoppel or laches does not apply against the government suing in its capacity as sovereign. 223 In this case, it is beyond dispute that the Republic, through Solicitor Carriazo, was acting in its sovereign capacity when it appeared in the hearing of the Del Rio petition. The issue of reconstituting a title of dubious provenance and covering vast tracts of land necessarily called for the Republic's assertion of its territorial integrity and dominion. Surely, the doctrine of estoppel cannot be applied to the extent of impairing the sovereign powers of a state. Fourth issue, whether or not a petition for annulment of judgment under Rule 47 of the Rules of Court is the proper remedy. We rule in the affirmative. The provisions of Rule 47 relevant to our inquiry are as follows. Section 1. Coverage - This rule shall govern the annulment by the Court of Appeals of judgments or final orders and resolutions in civil actions of regional trial courts for which the ordinary remedies of new trial, appeal, petition for relief or other appropriate remedies are no longer available through no fault of the petitioner. Section 2. Grounds for annulment - The annulment may be based only on the grounds of extrinsic fraud and lack of jurisdiction. Extrinsic fraud shall not be a valid ground if it was availed of, or could have been availed of, in a motion for new trial or petition for relief. Section 3. For filing action - If based on extrinsic fraud, the action must be filed within 4 years from the discovery, and if based on lack of jurisdiction, before it is barred by laches or estoppel. 223 Republic vs. Gobon Lee, GR number 5011499, April 29, 1961, 1 Scrar 1166. See a GRSP number 70014 and 104604 decision. Page 60. Note that there are 3 requirements that dictate the propriety of the availment of the remedy of annulment of judgment. 1. The ground/s, which are restricted to extrinsic fraud and lack of jurisdiction. 2. The timeliness of the filing, which is 4 years from discovery, if based on extrinsic fraud, or before it is barred by laches/estoppel, if based on lack of jurisdiction. And 3. The non-availability of other appropriate remedies through no fault of petitioner. All were satisfactorily discharged by the Republic. In the instant case, the first requirement was satisfied when jurisdiction over the Del Rio petition, the Tallano Acop petition, and even the original petition for a constitution was not acquired for non-compliance with Act No. 3110 and RA No. 26. Meanwhile, we have also established that estoppel/laches does not run against the Republic, acting in its sovereign capacity. Nor can the mistakes of its agents prejudice the Republic. These take care of the second requirement. As regards the third requirement, we find enlightenment, and thus accord merit in the explanation of ASG Balasilo on the OSG's choice of remedy. We quote relevant portions of his affidavit, 224 to wit. 8. It was only in 1997, when the petition for a constitution dated June 27, 1997 of Judicial Records title Heir in Del Rio petition was filed with the Regional Trial Court of Pasay City, that the OSG received copies of the alleged decisions, orders, titles, and related documents sought to be reconstituted. 9. Prior to June 30, 1997, no notices, court rulings, or papers were received by the OSG from the court or the parties in connection with the alleged proceedings in civil case number 3957P. The alleged decisions, orders, writs and related documents sought to be reconstituted in 1997 were never received by the OSG at the time they were allegedly issued by, or submitted to the court. XXX. 224 Supra, Note 216. See a GRSP number 70014 and 104604 decision. Page 61. 13. When Branch 111, Regional Trial Court of Pasay City here in Respondent Court issued the orders dated July 7, 1997, July 11, 2001 and October 8, 2001, Solicitor Thomas M. Navarro and I took the position that Neither appeal from said orders, nor a petition for certiorari, nor a petition for relief from judgment was adequate, because said orders merely reconstituted the decisions, orders, or writs, allegedly issued prior to 1997. There is a more basic need to seek the annulment of the alleged decisions, orders, titles or writs earlier issued, and which were allegedly burned in 1992. There is a compelling necessity to once and for all, bar any subsequent attempt, to reconstitute them in the future. 14. An appeal, petition for certiorari or petition for relief from judgment from the 1997 and 2001 orders would have merely annulled said orders, but not the alleged titles directed to be reconstituted in the alleged decisions, order and writs allegedly issued by the trial court before the burning of the records of Branch 111. Regional Trial Court of Pasay City on January 18, 1992. Furthermore, appeal and petition for relief from judgment are not the proper remedies to assail said orders issued in 1997 and 2001, because they are void due to utter lack of jurisdiction, and these orders, though may be considered judgments, never gain finality. XXX. 16. For the foregoing reasons, the Republic of the Philippines can only avail of the petition for annulment of judgment of the Regional Trial Court under Section 9(2) of the Judicial Reorganization Act and Rule 47 of the 1997 Rules of Court, to secure complete relief for the Republic. Thus, the ordinary remedies of new trial, appeal, petition for relief and other appropriate remedies are either not available or no longer available through no fault of petitioner Republic of the Philippines. Underscoring and editing supplied. Also, it is well to remember that where a petition for annulment of a judgment or final order is grounded on lack of jurisdiction over the nature or subject of the action, as in this. See a GRSP number 70,014 and 104,604 decision. Page 62. Case, the petitioner need not allege in the petition that the ordinary remedies of new trial, motion for reconsideration, or appeal are no longer available through no fault of its own. This is so because a judgment rendered, or a final order issued by a court without jurisdiction, is null and void, and may be assailed anytime either collaterally, or in a direct action, or by resisting such judgment/final order in any action proceeding, whenever it is invoked, unless barred by Laches 225. See a GRSP number 104,604. Fifth issue, whether or not indirect contempt was committed by respondents. We rule in the negative. The power to punish for contempt is inherent in all courts, and is essential to the preservation of order in judicial proceedings, and to the enforcement of judgments, orders, and mandates of the court, and consequently, to the due administration of justice. 226. However, such power should be exercised on the preservative, and not on the vindictive principle. Only occasionally should the court invoke its inherent power, in order to retain that respect without which the administration of justice must falter or fail. Only in cases of clear and contumacious refusal to obey, should the power be exercised. Such power, being drastic and extraordinary in its nature, should not be resorted to unless necessary in the interest of justice. 227. In this case, petitioner Salas et al. That respondents Myra, LTO, and Pasay City government committed indirect contempt when they facilitated the issuance of a building permit, leading to the eventual construction of building within the area which is allegedly part of the real property subject of LRC/civil. 225. Cianchita vs. Anchita, GR number 145,370, March 4, 2004, 424 SCRA 725. 226. Heirs of Delian Viuda de Rojas vs. Court of Appeals, GR number 138,660, February 5, 2004, 422 SCRA 101. 227. Abab vs. Samra, GR number 82,216, July 2, 1990, 187 SCRA 75. See a GRSP number 70,014 and 104,604 decision. Page 63. Case number 3957P, the records of which are in turn the subject of KOR.G. on number 70,014. Petitioners Solis, et al. Then allege that respondents' acts violated the writ of preliminary injunction 228 we issued in CRGRSP number 70,014. The writ of preliminary injunction was worded in this wise. Now therefore, you, the respondents, are hereby enjoined from enforcing the orders dated July 7th, 1997, July 11th, 2001, and October 8th, 2001, in civil case number 3957B and from conducting further proceedings in said case until further orders from this court. Clearly, said writ was directed against the respondents of CRGRSP number 70,014 and no other. To recapitulate, the respondents in CRGRSP number 70,014 are Regional Trial Court, Branch 111, Pasay City, AM Acop, AM Acopiado, JM Tallano, and the Registers of Deeds of the provinces of Rizal and Bulacan. Evidently, MIRA, LTO, and the Pasay City government were never made respondents therein. Reasons of fair play and common sense, thus, dictate that respondents MIRA, LTO and Pasay City government cannot be held liable for indirect contempt. Simply, it would be the height of injustice to punish MIRA, LTO, and the Pasay City government for violating a writ of injunction not directed against them, in a case to which they were never made parties. An act to be considered contemptuous must be clearly contrary, or prohibited by the order of the court. A person cannot, for disobedience, be punished for contempt, unless the act which is forbidden or required to be done, is clearly and exactly defined, so that there can be no reasonable doubt or uncertainty as to what specific act or thing is forbidden or required. 229. 228 Supra, Note 116. 229 Lewin vs. Mahine, GR number 169476, June 16th, 2006, 491 SCRA 253. CRGRSP number 70,014 and 104,604 decision. Page 64. Indeed, the propriety of the issuance of a restraining order and the writ of preliminary injunction is but a mere incident to the actual controversy, which is rooted in the assertion of the conflicting rights of the parties. 230 It is not a cause of action in itself, but merely a provisional remedy, an adjunct to a main suit. Thus, a person who is not a party in the main suit cannot be bound by an ancillary writ. He cannot be affected by any proceeding to which he is a stranger. 231. Epilogue. A final note. Like a malignant tumor that innocuously began as a mere growth, this long drawn-out case has maliciously spread and spawned a host of complications, in the process posing serious threats to our system of land registration and land ownership, and causing inconveniences to many. The following disquisition from Ortegas and Company Limited Partnership vs. Velasco 232 is apt. We can take judicial notice of innumerable litigations and controversies that have been spawned by the reckless and hasty grant of such reconstitution of alleged lost or destroyed titles, as well as of the numerous purchasers who have been victimized by forged or fake titles, or their areas simply expanded through table surveys with the cooperation of unscrupulous officials. So too, this court has stressed that lands already covered by duly issued existing Torrens titles which become incontrovertible upon the expiration of 1 year from their issuance under Section 38 of the Land Registration Act cannot be the subject of petitions for reconstitution of allegedly lost or destroyed titles filed by third parties without first securing by final judgment the cancellation of such existing titles. And as this court reiterated in the recent case of Sylvester vs. Court of Appeals GR numbers L32694 and L33119, July 16, 1982, in cases of annulment and / or a conveyance of title, a party seeking it should establish not merely by a preponderance of 230 estate or heirs of the late Justice O.C.B. L. Reyes vs. City of Manila, GR number 132431, February 13, 2004, 422 SCRA 551. 231 Mabeo Farms Incorporated vs Honorable Court of Appeals, GR number 140058, August 1st, 2002, 386 SCRA 110, 232 Supra, Note 197. SEA GRSP number 70014 and 104604 decision. Page 65. Evidence but by clear and convincing evidence that the land sought to be reconveyed is considering the ease and facility with which documents are made to appear as official and authentic, for instance, from mere Xerox copies and certifications of officials supposedly signed with the seals of their office affixed therein. Wherefore, premises considered, we render judgment as follows. As to SEA GRSP number 70014. 1. The reconstitution proceedings in LRC/civil case number 3957P in respondent court are declared void for lack of jurisdiction. To the following decisions, orders/writs/ and other documents are annulled and declared void, and of no force and effect. A decision with compromise agreement dated February 4, 1972, 233, consisting of 139 pages. B. Clarificatory order dated March 21, 1974, 234, consisting of 30 pages. C. Decision dated November 4, 1975, 235, consisting of 44 pages. D. Clarificatory decision dated January 19, 1976, 236, consisting of 60 pages. E. Entry of judgment dated June 14, 1972, 237, consisting of 7/6 pages. 233 Supra, Note 6. 234 Supra, Note 7. 235 Supra, Note 8. 236 Supra, Note 9. 237 Supra, Note 10. SEA GRSP number 70014 and 104604 decision. Page 66. Effort of execution, demolition, and possession dated September 10, 1974, 238, consisting of 14 pages. G. Certificate of Sheriff's Return dated November 17, 1974. 239. H. Letters of Administration dated July 7, 1976. 240. I. Certified True Photocopy of Judicial Form number 140, GLRO Form number 68, Book number 34 of TCT number T408, 241, consisting of 7 pages. J. Certified True Photocopy of TCT number T498, 242, consisting of 7 pages. K. Order of Third alias Writ of Execution, Possession, and Demolition dated May 28, 1989, 243, consisting of 55 pages. L. Order dated July 7, 1997. 244. M. Order dated July 11, 2001. 245 An. N. Order dated October 8, 2001, 246. 3. TCT number T408 and TCT number T498, which were reconstituted pursuant to the order dated July 11, 2001, are declared void accordingly. The registers of deeds of the provinces of Resel and Bulacan and Giginto, Bulacan are directed to cancel TCT number T408 and TCT number T498. 238 Supra, Note 12. 239 Supra, Note 13. 240 Supra, Note 14. 241 Supra, Note 15. 242 Supra, Note 16. 243 Supra, Note 17. 244 Supra, Note 18. 245 Supra, Note 19. 246 Supra, Note 20. SEA GRSP number 70014 and 104604 decision. Page 67. 4. The writ of preliminary injunction issued by this court on June 25, 2002 is made permanent. 5. The heirs, agents, Privis, or anyone acting for, and in behalf of J.M. Tallano, A.M. Acop and A.M. Acop are enjoined from representing or exercising any acts of possession ownership, or from disposing in any manner, portions of the land covered by alleged TCT number 408, TCT number T408, and TCT number T498. As to see a GRSP number 104604. 6 respondents: Manila International Airport Authority, Land Transportation Office and Pasay City Government are declared not guilty of indirect contempt. Consequently, the petition for indirect contempt against them is dismissed for lack of merit. So ordered. Magdangal M. Delian, Associate Justice. We concur. Hakim S. Abdul Wahid, Associate Justice. Estela M. Perlis Bernabe, Associate Justice. See a GRSP number 70,014 and 104,604 decision. Page 68. Certification pursuant to Article 8, Section 13 of the Constitution, it is hereby certified that the conclusions in the above decision were reached in consultation before the case was assigned to the writer of the opinion of the court. Hakim S. Abdul Wahid, Associate Justice. Chairman Special Former 2nd Division.